12th of March 2025, my lord. Grateful, my lord.
Lordship, this is the testamentary matter pertaining to year 2012.
This court is not having determination of the testamentary.
But Lordship, as for the list,
Which list?
the original side list,
Show me.
except the arbitration matter, you have determination of all the matters.
May have you? What is stated? Testamentary coming under the commercial division.
Lordship,
Yes.
I would like to make a mention for item 5, Lordship.
Item
5.
Yes.
For this, we have sent a mail to the opposite side, a request for the adjournment for the personal difficulty in my family, Lordship.
Okay, come at 2. Let me see.
Lordship, I have informed to the opposite side.
Okay,
also.
other party come. I will take the matter. When the matter will call, I will see what is the matter.
Okay.
My lord, may I
No
have your lordship's leave
Your
to
turn.
mention, my lord, that testamentary matter which was fixed on 2nd April, my lord.
Testamentary matter before.
My lord, it was part heard. The arguments were going on, my lord.
Acha, that one.
My lord, may that appear any day subject to your lordship's convenience at a fixed time.
When
my
it is
lord.
fixed?
It was fixed on 2nd.
Second. Friday list. Okay, on that day.
Friday, last Friday also it appeared, but no time was fixed, my lord.
You want a time?
Yes, my lord.
Okay, come on Friday. Come on Friday, and I will fix the date.
I'm deeply.
Because in presence of both the parties, I will fix the date.
I appear for defendant number 2 and 3.
Yes.
And I have not been given any notice.
No notice. This court has fixed on as per the order passed with as per the direction of this court. The matter is has to be mentioned.
Miller.
Why it is mentioned? Because it is fixed on 9th and 10th and 11th
10th
April
and
2
11th.
PM.
Miller.
Correct. So 9th April is Wednesday. 2 PM it can't be taken because the company matter is listed.
Miller.
As per okay. And 11 also it can be taken because it is the non-commercial matter will be taken at 2. So that's why it is
It will
fixed
be taken
today.
on 10th.
Neither 9 nor 10 the matter cannot be taken off at 2 PM because on 9th company matter is fixed from 2 PM onwards and 11th the non-commercial matters will be taken up by this as per my determination.
And my lord,
So
it kindly keeps it on some.
So 11th April, 10th April it can be. 10th April it will be taken, no problem. But 9th and 11th it will not be taken.
10th can be taken.
10th it will be
Then
taken.
let the 10th remain.
Okay, so that's why I am informed this. 9th and 11th it will not be taken. 10th
And
let the matter come on.
kindly because this now this was taken up on 19th last. And my lord is fully aware of the facts. 19th. Now my lord kindly kindly give some consecutive dates, Miller, next.
Correct. Come on 10th. Let the 10th then on.
The ID will get filled.
Already my diary is already even.
Yes, Miller, kindly give some consecutive dates, Miller. I want to take advantage of today's. Let the 10 be remain. Yes, 10
remain. 10
other 2 days, your lordship.
Huh?
2 PM.
21st at 2 PM and 22nd at 3 PM. The matter is listed as to be mentioned as per direction passed by this court. By an order dated 19th February 2025, the matter is fixed on 9th April 2025, 10th April 2025 and 11th April 2025 at 2 PM. But due to the change in determination, the matter could not be taken. The 9th April 2025 and 11th April 2025 matter will not be taken up for hearing as on the said date, the company matters and non-commercial matter is fixed by this court as per determination. In view of the above, instead of 9th and 11th April 2025, list the matter on 21st April 2025 at 2 PM and 22nd of April 2025 at 3 PM. With regard to the hearing on 10th April, the matter will appear on 10th April at 2 PM.
Remain. Good.
Yes.
We know the context
I
now.
believe yes.
We now know the context why both of us were unsure of why it had come. Your Lordship,
Well, it
he
is
has
to
a
appear
little
on
difficulty on 10th,
10th.
so it could be taken up on 21st.
or any date convenient.
22nd already fixed.
21st.
What is the hearing?
No, no,
Well,
this is
examination, witness examination in chief, my lord.
Your Lordship, 24th. I'm not in Calcutta. That's my personal
That nahi
difficulty.
hai. Acha, Wednesday. So 28, 29. Fix it. 28 at 28 2 p.m.
Very good. Lordship,
The matter is listed as to be mentioned as per the direction as per the direction of this court. The matter is fixed on 9th April 2025 at 3 p.m. for further examination of plaintiff witness and cross-examination. But on 9th April 2025, the matter will not be taken up for hearing due to the fixing of company matters on the said date. Accordingly, the full stop. Let the matter appear on 28th of April 2025 at 2 p.m. At 2 p.m. for further examination of plaintiff witness and cross-examination instead of 9th April 20. Yes, next.
Item number 3 is appearing at my instance.
Yes.
This matter is with regard to an extension that my lord had granted for carrying out the rectification of defects as indicated. My lord, I am praying for an extension because on the last occasion, my lord granted 7 days time. It took us almost 3 days to get the file, and thereafter there were 3 holidays in the middle, which were notified subsequently. So, my lord, I am praying that if 2 weeks or 3 weeks time is given, because again next week may be a problem. There's 6 defects, my lord. I have my documents are ready. I will only have to go to the department and carry out the corrections, and some verification is required, for which I will have the person brought down.
The matter is listed as to be mentioned as per the prayer made by the counsel for the plaintiff. By an order dated 24th of March 2025, this court has directed the plaintiff to rectify the defects within a week from the date, and also to re-verify and reaffirm the affidavit within a week thereafter. Counsel for the plaintiff prays for extension of time to rectify the defects and to re-verify and reaffirm the affidavit. Accordingly, time to rectify the defects and to re-verify and reaffirm the affidavit is extended for a further period of 2 weeks.
My lord will kindly grant me time till 28th, my lord, because even if it is 3 weeks, my lord, next week there may be some difficulty in getting the ministerial work done.
28th of April
Yes, my lord, 28th
is
April.
extended till 29th of April 2020. Next.
This we are appearing for the decree holder, my lord.
My lord, decree was passed by your lordship. Thereafter, my lord, we had filed the execution application, my lord. This was
No,
released by.
Your
My lord,
Lordship, I am
they
appearing
have
for the respondent
filed
number
appeal,
2.
and their time they were granted time to file put in the security, which they have failed. My lord, they made the defendant number 2 had filed an extension application for extension of such time. My lord, that was also dismissed. My
Your
lord,
Lordship,
no
Your
state
Lordship, we
appeal,
are willing to pay the decretal amount, Your Lordship.
that
Your
was
Lordship,
not granted by the
we
appellate
wish
court.
to, before the appellate court, we will make
My lord, this
appropriate
is the order
applications, Your
passed by the
Lordship.
appellate court.
We are intending to pay, Your Lordship, and we will make appropriate applications before the appellate court, Your Lordship. Your Lordship will kindly grant us some time for that, Your Lordship.
That cannot be, my lord. It has been. We are
Your
only
Lordship,
asking for execution of the decree.
if we are willing to pay, Your
appeal
Lordship,
court
why
had
should Your Lordship
passed its
proceed
order.
with the execution? We are willing to pay the decretal amount, Your Lordship. My clients are in Delhi, Your Lordship. It's very difficult for me to coordinate with them, Your Lordship. Therefore, the delay had happened, Your Lordship. But they are willing to pay. That is my instruction.
Yes, paragraph 4 of the appellate side, madam, order of the appellate court. It needless to mention that in the event the said security is not furnished, the decree shall be become executable. You have not filed, you have not deposited, it is on date, order dated 12th February 2025.
Yes, Your Lordship, because we did not have appropriate instructions at that time, Your Lordship. We
My
were
lord,
willing.
on 10th of December, this order was passed for a
Your
direct
Lordship, there was a
put in
bereavement
the
in the family of the
security.
advocate on record, Your Lordship.
Thereafter, they failed.
12th February, the category needless to mention that even the security appeal is admitted, appeal is
Your
ready. to-
Lordship, last chance may be given to us, Your
But
Lordship,
there's
to
no
proceed
stay.
before the
This court
appellate.
can't.
This court, but the appeal court has.
Not. Because the appellate court has directed. Now this court cannot override the order of the appellate court,
Deeply
madam.
obliged, Your Lordship. আর কিছু দেখাবার দরকার নেই।
Lordship will give some time.
I am fixing tomorrow. If you'll deposit by tomorrow, then I'll fix it tomorrow. Otherwise, then I have to take issue the appropriate. I have to pass appropriate order.
Lordship, instructions it will go in the form of a bank guarantee, Your Lordship.
What?
So, Your Lordship, that will take some time with the bank. So maybe
we were aware
within this
of
week, Your
Pascal,
Lordship. Your Lordship can list it on Monday.
In September, they've listed on Monday, my lord.
December it is fixed. The order was passed. Then February.
Well,
order-
the
Or
first
Your
order
Lordship
was
can
passed
fix
on
it on
11th of
Friday. Your
September.
Lordship can fix it on Friday. I'll get some time to make the payment, Your Lordship. My
But that
clients are in
cannot
Delhi,
be.
Your Lordship. My
This was the
clients are in
first
Delhi, Your
order.
Lordship. That is the only difficulty. Otherwise, I wouldn't have insisted.
But from September, they're unable to get the instruction
Now we have the instructions, Your Lordship.
at their own sweet
There
will
are
and
different
time. They will
levels of
come before the
hierarchy
court
in
and
that
make such submissions.
organization, Your Lordship. The payment was
My lord,
not
let them file their
sanctioned.
affidavit of assets.
Okay, I am fixing on 10th. If
Friday.
you deposit, it's okay.
Friday, Your
Not-
Lordship.
Not Friday 10th.
My lord,
And
they
they
have to file their affidavit
Friday, Your
of
Lordship.
assets.
Kindly, Your Lordship.
On
Kindly.
10th, they will
I
not
appear for
deposit.
respond number 1. I have some submission, Lordship. No notice was served, Lordship.
Not necessary.
Lordship, we don't have, we have not been served with a copy of the execution
Necessary.
certificate.
Within 2 years. Within 2 years, execution is filed and appellate court is already
And
directed to
today also
deposit.
it has
You are appearing
appeared
for whom?
before
I'm
assigned.
appearing for Amazon.
Madam, you are
Seller
appearing
service
for?
respond.
Number 2.
So,
Lordship, according to the 12th February order, Lordship, we are ought to submit the decretal amount by 26th.
correct.
Lordship, our client's head office is in Bangalore and their financial department is in Delhi. So we have to coordinate along all along. Lordship, we have the DD with us. It
Hmm.
was dated 28. Thereafter, an extension petition was made before the division bench, Lordship.
Hmm.
Now that was rejected due to some inadvertent mistakes.
Correct.
Lordship, we will again make the we have
That's
submitted
why
the
I am
cost as
fixing
well.
on 10th. Let come with the 10th with the
Once the
report of
appellate court has
Yes.
dismissed it, disallowed that,
So,
can they come before this court and
It
claim
was
for
a-
extension?
Your Lordship will kindly make it 11, Your Lordship.
no,
Your
no,
Lordship,
11 no, madam. Sorry. I am fixing on 10th.
Very
I'm grateful to Your Lordship. I'm so grateful.
So suffering for the decree holder, so suffering for the judgment debtors. As per the prayer made by the council for the judgment debtors, the case adjourned. Let the matter appear on 10th April 2025.
I'm deeply obliged, Your Lordship.
I'm grateful to Your Lordship.
Under the same heading.
Lordship, this is my application on the last day, my lord, your lordship, the application, my lord, on the order 38/6. My lord, on the last day, your lordship, my lord, had directed, my lord, the learned receiver, my lord, to go to another property
Yes.
and make an inventory. Before court number 23.
Yes, file report. Where is the receiver?
Blood, I appear for blood. I am the receiver, blood. Blood, I
Yes.
have carried out the duties, blood, and I have the report. Blood,
Ah.
right now, blood, I am in legs in blood before courtroom number 23.
I am passing you.
Yes, blood, kindly, blood.
Pass.
Blood, kindly, blood, if my lord permits, blood, kindly keeps it at 1. I shall come at 1.
Come at when you complete your work.
Very well. I'll come at 1. Well,
Extremely
he's on
grateful,
his
blood.
legs.
Extremely.
Grateful. Well.
Item number 9, my lord, I appear on behalf of my lord, the defendant, my lord, opposing this application. My lord, on the last occasion, my lord, my lord, this is an application for, my lord, amendment of the written statement, my lord, by bringing a new, my lord, counterclaim. So, my lord, they are doing it, my lord, after a period of almost 8 months from the date of, my lord, the expiry of, my lord, the time to file, my lord, the written statement.
Lordship, I appear for the defendant. Mr. Rohit Banerjee is the counsel representing the defendant. He is
Huh?
not today before the High Court, Lordship. He has not been able to reach today. I was
I'm
seeking for
dismissing
a.
it. Last occasion also you said
No, it was
My lord,
the
I
plaintiff, your
should
Lordship.
be candid before your lordship, my lord, it was me.
It was
my lord,
not us. Mr. Banerjee was present on the earlier occasion.
You are appearing for whom?
I am appearing for, my lord, the plaintiff, my lord,
You are for the plaintiff.
plaintiff response.
But for 24 January, counsel for the defense, I mean the arguing counsel is out of station and pressed for time.
Oh, 24 January.
24 January order.
Lordship,
It is you.
Lordship, our application was that for the amendment of the written
Correct.
statement. That is the application we filed.
Correct. It's the commercial matters.
Yes.
How many days the court can adjourn the matter?
Lordship may take up tomorrow. Lordship, Mr.
Court
Banerjee
should
might
go by
be
its
present.
own diary, not by your submission. Not today.
Published.
My lord, I have an application for appointment of commissioner on the last occasion.
For
Your
what?
lordship, on the last occasion, with regard to the appointment of commissioner, commissioner was appointed, cross-examination and chief was complete with regard to the plaintiffs. Subsequently, they had filed an application under Order 7 Rule 11. With regard to Order 7 Rule 11, on the last occasion, your lordship observed that since the commissioner has taken the done the examination cross-examination regard to the plaintiffs, the defendant should be completed, and at my cost, I have filed an application that is IAGN number 5
For what?
for with regard to the balance of the cross-examination examination of the defendants.
My lord,
And
yes.
your lordship observe that your lordship will hear all the issues at the time of argument by framing the issue.
My lord, may I just humbly submit? My lord, GA4 is, my lord, our application, my lord, where I am appearing for the defendant, my lord, petitioner here, my lord.
7 Rule 11.
My lord, Order 7 Rule 11. My lord, I have, my lord, some points, my lord, which I want to argue before your lordship, my lord.
I will take all the points along with the main argument because evidence has been led, cross-examination has been done.
My lord,
So
only.
at this stage, if you want, I will allow 2,50,000 to the plaintiff.
My lord, if your lordship,
If you want to argue the matter of Order 7 Rule 11 after the evidence, 2,50,000 pay the cost, 50,000 to the legal aid, 2 lakh to the plaintiff. I will hear the 711. Or otherwise, if you don't willing to pay the cost, I will pass an order on your Order 7 Rule 11 will be one issue in the argument. The argument will be taken off. What are the point you give as per your 711? You argue along with this. I will frame the additional issue at the time of hearing.
my lord, as your lordship pleases. Lordship, kindly, subject to your lordship's kind convenience, kindly let us, my lord, frame an additional issue as to maintain everything. Because I have, my
Let
lord,
first evidence is completed.
It's already
no,
issues
PW1 only.
Where is the report?
it's already
PW1.
Who is the
PW
commissioner?
not completed.
issue well, issues are already there.
No, issues are there. Let first evidence
My
be
lord,
completed. I will
item
keep
number
your evidence. I will keep your section.
Issue number 6, it is there, my lord. Whether
That's
the
why I will keep the GA4 on record, and at the time of hearing argument, if this court find in as per GA4, further additional issues to be
Grateful,
framed, that can be.
grateful.
There's no problem.
My
Law provide that.
lordship.
So what is the stage of the evidence before the commissioner?
state of the evidence, my lord, with regard to the plaintiffs, it has been completed. With regard to the defendants, examination and cross-examination has to be completed.
Has to become. How many witnesses you are having?
My lord, as of now, one witness I am told.
Hmm.
My lord, as per instruction, my lord.
So how soon you will produce the witness before the commissioner?
My lord.
How
My lord,
soon?
2 weeks time. My lord, 1 week time may be granted, my lord, to prepare judges.
Correct. No, I will grant time. No problem. So you will not adduce any further evidence?
No, my lord, we have
Only one witness you examine
yes,
or two?
one witness.
One.
we have
And cross-examination.
cross-examination completed. The
So-
same commissioner, my lord, I pray because Prabhakar Chaudhary, IAGA number 5 application, prayer is there, my lord.
And what is the GA4? 5.
GA5 is this my application for Commissioner, my lord, for continuation of the proceedings. My lord, already he has filed a report. Your lordship will file. Lordship will see the Commissioner has filed a report, Annexure D, page 11. He has filed a final report, and subsequently the Prabhakar Chaudhary, my lord, the spelling
Suffering for the defendant.
is wrong in the.
Defendant has filed an application being GA Com 4 of 2024 under Order 7 Rule 11 of the Code of Civil Procedure for rejection of plaint. It is fine from the record. The case is at the stage of evidence and the plaintiff witness has been examined and cross-examined by the commissioner. Full stop. Counsel for the defendant submitted, the defendant will also adduce the evidence. Full stop. In view of the above, this court is of the view the application filed by the defendant being GA4 of 2024 for rejection of place will be taken up for hearing at the time of final argument of the suit, and if required, additional issues will be framed. Let GA Com 4 of 2024 be kept with the record.
Lord, only one thing. May I file my affidavit in reply, my lord, to
The
their
affidavit in reply filed by the defendant in connection with GA4 of 2024 be kept with the record.
Lordship.
Full stop. The defendant is directed to file the examination in chief of the defendant witness number 1 before the learned commissioner within
My lord, a period of
within 2 weeks from date after serving the copy to the learned counsel for the plaintiff. Full stop. The commission is directed that after receipt of the affidavit of evidence of the defendant's witness to fix the matter for examination of the defendant witness. Full stop. The commission is directed to complete the evidence of the defendant witness within a period of 4 weeks from the date of receipt of the copy of the affidavit of evidence of the defendant's witness number 1.
my lord, since we have not filed, my lord, the judge's brief, my lord, lordship may kindly allow us, my lord, 1 week time, my lord.
Judge's brief. Their evidence is over.
No, we have not filed our, my lord.
So how you cross-examine? If you are not filed, how you cross-examine the plaintiff witness?
They have relied upon our
We have
judge's
relied
brief
on
and
some-
cross-examined
We
everything,
have
my lord.
relied
They
on,
are shut.
but my lord,
they have
some more
shut down
documents
their-
we want to rely, my
But
lord.
have you disclosed that document? Otherwise,
Yes, we have
commercial
disclosed.
suit.
Disclosed.
I'm not standing.
Disclosed.
The counsel.
No documents has been disclosed by them.
No, it is disclosed.
A written statement. Guy.
Same documents has been relied by both the parties, my lord.
Written statement.
If necessary, they will
Already,
file-
my lord, disclosed.
file for-
These are commercial suit. If it is not disclosed, then this order will be
My
created.
lord, I have to, my lord, I have disclosed.
Give the written statement.
The documents they have relied upon has already been included in my judge's brief. My lord, I am led by Mr.
Document.
Your lordships will find in our judge's brief, if your lordship has, Lord, we've relied upon our documents as well as the DD1 or the DD series is the, Lord, the documents which the defendant has relied upon.
WSA.
Lord, lordship will find from serial number 14 of the judge's brief, Lord, DD1 onwards. Lord, Roman 4, page number Roman 4, my lord.
PD number 14.
Lord, from item number 14, lordship will find defendant's document 1 onwards.
Protested copy of the plaint. Server copy of the order.
Take the plaint.
Server copy of the order. They have disclosed only how many documents?
My lord, we have disclosed, my lord, Annexure C, my lord, I do
15
not find, my lord, in the list.
Huh?
Subject to my learned friend says, my lord, Annexure C of my written statement.
July 19th order to. Dekhun July 19th.
Annexure C, which paragraph? Which paragraph?
Lord,
Annexure
page 5, my lord,
Achha.
paragraph Roman 3.
They are item 29.
Lord, item 29 is there. Lord, the division bench order which my learned senior friend seeks to rely upon. Lord, page 88. July.
Oh, Namtani. Lord, then, my lord, I'm.
It is there.
Well.
All documents are there. हाँ, क्या बोला?
Yeah.
Complete the evidence of the defendant witness within a period of 4 weeks from the date of
Weeks.
receipt of the evidence of the defendant witness number 1. Okay. Remuneration, what was the remuneration?
Lord, as your lordship pleases, my
Per,
lord,
per,
my lord.
per sitting it was not given. By which order he was appointed? You have paid.
My lord, we have paid. My lord, kindly looks at the order of 11 June 2024. My lord, wherein my lord, lordships had my lord, fixed the fee 75. My lord, this was subsequently, I'm told, has been revised on my lord, lordship will find the order of 19 June 2024. It was revised to 60. My lord, my lord,
60,000.
yes, my lord, I leave it to your lordship, my lord, whatever
What
lordship.
is the there that is to be paid
My
by
lords,
the,
my lords.
the defendant is directed to pay the remuneration to the London Advocate Commissioner in terms of the order dated,
My lord,
the revised order.
it is their
19
application.
June 2024. 19 June 20.
19th June 20.
My lord, commissioners, my lord, they are seeking, my lord. My lord, we are not seeking. If your lordship kindly directs them to pay, my lord. Otherwise, my lord,
How it can be?
my lord, we are ready to, my lord, do it here, my lord. Subject to your lordship's convenience, my lord. My lord, previous occasion also, my lord, they sought for.
Then give the 50-50.
Would be little bit inconvenient for us, my lord. If
No,
your
no, क्या
lordship
बोला?
kindly considers, my lord.
Now, the remuneration of the commissioner shall be paid in terms of the order dated 19 June
2024, my lord.
19 June 2024, and the remuneration shall be paid. The plaintiff shall pay rupees 40,000 and the defendant shall pay 20,000.
Grateful, lordship.
And my lord, commissioner's name be cleared, my
The
lord.
same report, the same commissioner is there.
Same, my lord.
The commissioner who was appointed by the order dated
10th July 20.
10th July 2024 shall continue as commissioner to complete the recording the evidence of the defendant and to file the report.
Grateful.
Deeply obliged.
On 10th June 2025.
My lord, in item number 11,
I appear for the defendant
I'm
number 2.
appearing for plaintiff, my lord. My lord, in this matter, my inspection discovery is complete, my lord. And admission denial is pending, my lord. So kindly praying for 2 weeks time, my lord.
Admission denial is pending 2 weeks.
One
But
actually,
I
but
have
this was actually
prepared,
change
I'm done,
brief,
my
my
lord.
lord. That's why, my lord. otherwise
So far,
it was change brief, my lord.
maybe December 2024, discovery and inspection order was passed. Yes.
so far as I'm concerned, my lord, my affidavit and admission and denial is ready, my lord. And also, my lord, the suggested issues, my lord, I have prepared. But I appear only for the second defendant. my
Number
lord.
2. What about the other defendant? They are not appearing.
First is not appearing, my lord.
Only 2 defendants are there.
Yes.
So and so appearing for the plaintiff. So and so appearing for the defendant number 2. Counsel for the defendant number 2 has filed affidavit of admission and denial of the document and suggested issues. After serving the copy to the London Counsel for the plaintiff, let the same be kept with the record. Counsel for the plaintiff prays for 2 weeks time to file affidavit of admission and denial of the document and suggested issues. In view of the submission made by the counsel for the plaintiff is adjourned. The plaintiff is directed to file the affidavit of admission and denial of the document and suggested issues within 2 weeks from date after serving the copy to the London Counsel for the plaintiff. Please the matter to the defendant number 2. Let the matter appear on 24th April 2025 for framing of issues.
Very well.
In item number 12, I appear for the defendants.
Yes.
It may come back to my lord. There were 2 suits filed by the plaintiff against my clients. In one of the suits, as defendant, I had filed, my lord, a counterclaim. They were delayed in filing their additional written statement to the counterclaim. The matter was heard at length by your lordship, and after considering the law elaborately on the subject, my lord was pleased to dismiss that application. Thereafter, they preferred an appeal. The appeal was also heard in detail by the learned division bench, and the learned division bench was pleased to uphold your lordship's order and dismiss the appeal. Now, this is the other suit preferred by them, in which there is a pending application by which they have again asked for extension of time to file additional written statement, which of course should be covered by the appeal court
Well,
order.
the special leave petition will be filed tomorrow or day after. To that,
And let the suit proceed. If you got, then you will get the chance.
but I'm just saying, well, do not take up this matter till we get some
I'll leave it
relief
to
over there. Some relief over there. Maybe a week or 2 weeks. Madam. It's my suit only which is getting delayed. So really.
So and so appearing for the plaintiff, so and so appearing for the defendant number 1, 2, 4, and 6. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 29th April.
Grateful.
No. I am plaintiff in this matter, my lord. In compliance of your lordship direction, my lord, I have prepared the suggested issues and affidavit of admission, affidavit of denial of documents, my lord. I am filing it.
For the defendant, my lord.
All completed?
My lord.
There is no counterclaim.
No, my lord.
Why the issue number 3?
My lord.
Is there any bar?
No, my lord. No bar. My lord, it's as usual we have written, my lord. Only, my lord, issue number 7, it should be whether any other relief or relief the plaintiff is entitled according to law and
if you pay the amount in the 138, you take the defense.
I am for the plaintiff.
Whatever it may be. Issue number 3.
My lord,
You are for the defendant.
My lord.
Issue number 3, how it can be?
My
lord.
Why non-gender parties? You have taken the non-gender parties? Plaintiff. You have taken
I have taken this ground as because, my lord, whether the defendant cannot raise the issue.
Is there any is there any
because, my lord, they have not disclosed any document, single piece of
non-gender parties
in the written statement.
Non-gender, min-gender, they have taken any
No, my
then
because, my lord, they have not disclosed any document. For that reason, my lord, I have
they do not disclose, but they have not taken
my lord,
any plea whether the is the necessary party or is the non-gender party or misgender party. Then So you are 6 defendant. You are 6. Whether the
Well.
plaintiff is entitled to amount shown in the bill or invoices shown in the plaint disposition, when that only this I am reframing this issue, whether the defendant have received the invoices and bills or not.
My lord.
Correct.
As your lordship.
So I am taking the issue, your plaintiff issue number 2, 4, 5, and one issue is framed whether the defendant has received the bills of invoices or not. Then defendant issue number 1. I am taking only defendant issue number 1.
My lord, he's
Yes, your issue number 1. On all other thing we cover.
my lord.
So and so suffering for the plaintiff, so and so suffering for the defendant. Both the parties have filed their affidavit of admission and denial due document and suggested issues after serving the copy to the after exchanging the same between the parties. Let the same be kept with the record. Consider the submission made by the counsel for the parties, peruse the pleading and suggested issues. Following issues have been framed. This one, 1, 2, 3, this 4, and this 5. The plaintiff is directed to file judge's brief of document by disclosing all the documents within a period of
Well, I'm the plaintiff, my lord. Within 4 weeks, my lord.
4 weeks.
4 weeks, my lord.
Within 4 weeks, after serving the copy of the same to the learned counsel for the defendant. Full stop. The plaintiff is also directed to file the affidavit of evidence of the plaintiff witness number 1 within a week, 2 weeks thereafter.
Right.
Full stop. Please the matter. Give the date of witness action. Huh? 24th June. 24th June, 3 p.m. witness action of the plaintiff. Next.
May it please your lordship, I'm appearing on behalf of the plaintiff in a suit for recovery of money lent in advance, but I am in default. I was supposed to complete discovery and inspection and file affidavit of admission and denial.
But today, there's an application before your lordship, GA7, which is for rejection of the plaint.
Filed by you.
Filed by me. I am the defendant, the ground taken in the application is that if your lordship kindly takes the plaint, I'll not show your lordship my submissions will not be more than yes, kindly takes the application. GA7.
GA7 hai? Yes.
Kindly takes the plaint page 8. Lordship will find the defendant numbers 2 and 3 and the plaintiff were all acquaintance. As your lordship got paragraph 1 of the plaint, page 12 of the application.
Yes. 2 and 3 and the plaintiff were old acquaintance.
Were old acquaintance and were known to each other for a long time. Thereafter, it goes on to say that how the loan was given and what are the admissions taken in the given by or rather admitted by the defendant eligible. Now, my submissions are very simple. I will be relying on the Lady Moon judgment and the prime high tech judgment which your lordship had delivered to say that it does not come under one of the disputes under section 21C subsection 1. my lord, may I, my lord, hand over the judgments, but I'll not trouble your lordship.
No
My lord, that
mercantile.
also knows, my lord.
Asking for a short,
No mercantile.
my lord, short
No
time
mercantile,
to
no banking
file my
document, no
affidavit.
acquaintance, and my lord, they have only
Affidavit
stated
in
that.
opposition, my lord. Very short time because this is only one small legal point. And as it is, my lord, 7-11.
What is the
They
sixth?
cannot,
Yes,
my lord, improve the case which they have running
Sure.
in the plaint, my lord. But be
a
that
very
as it may,
short
my lord,
time
we
to file my affidavit.
What is the GS6?
But this has been disposed, my lord, on the last
Disposed of?
occasion. Yes. My lord, this
Disposed.
suit
Yes,
was
disposed
dismissed
of.
and then it was restored.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff prays for extension of time to complete the discovery and inspection of the document. You have completed? No.
No,
You are not disclosed. Full stop. In view of the submission made by the counsel for the plaintiff, time to complete the discovery and inspection of the document is extended for a period of 3 weeks.
File.
3 weeks. Full stop. The parties are also directed to file their affidavit of admission and denial document within a week thereafter. In the meantime, the parties are directed to exchange their affidavit, exchange the suggested issues. Full stop. Suggested issues. This the matter. Full stop. The defendant has filed an application being GA Com 7 of 2025. Order 7 Rule 11?
Yes. In the nature of, my lord,
praying for rejection of plaint. Full stop. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition file within 2 weeks.
File.
Reply
a week thereafter.
within a week thereafter. Full stop. Let GA Com 7 of 2025 be listed on 6th of May 2025.
If your lordship, my lord, kindly, my lord, then, my lord, if you are getting, my lord, 3 weeks time to come back before your lordship, if your lordship kindly extends the time to, my lord, complete the discovery inspection of documents to, my lord, instead of, my lord, 3 weeks, if we get some more time, because, my lord, ultimately everything will depend on, my lord, this application.
क्या बोला? List the matter on 6th May. उसमें बोला ना ऊपर exchange the affidavit in action, complete the discovery and inspection of the document within 4 weeks. ठीक है, affidavit of document within 2 weeks. ठीक है, 6 week हो गया ना. And in the meantime, list the matter on 10th of June 2025 for framing of issues. और ये hearing of G7 6th May.
Obliged.
Obliged. 1, 2, 3, 4, 5.
My lord, I am appearing for the defense.
Yes.
On the last occasion, your lordship was pleased to extend the time to file affidavit of admission denial by the defendants, my lord.
Yes, completed. For a period of 1 week, list the matter on 21st January. Meantime, the parties are also directed to exchange the suggested issues. Filed.
My lord, my instruction is, my lord, it has been 82. তাহলে তোমার হাতে কেন? তুমি ওকালত নাও। Yes,
But I have already
Affidavit of admission and denial. It has not been filed. My lord, এটা কি? It is to be filed. Okay, filed. My lord, it has been affirmed. My lord, kindly allow us to file it. My lord,
What?
my lord, the affidavit of, my lord,
Give the
admission and denial.
Give to the
My lord.
and what about the suggested issues?
my lord, I have already prepared, my lord. May I just
Your suggested issues?
they have served us
What?
copy of the
Suggested issues?
registration.
My lord,
Affidavit
only
document?
one modification I have done.
We have already
Filed.
filed that admission denial, my lord. Kindly allow us to file judge's brief of document and suggested issues to them.
আচ্ছা আমার কাছে কপি আছে।
Have you taken the plea in non-jointer parties?
My lord, I have. Non-jointer parties is one aspect. My lord, the other is
Concealment of fact.
my lord. And my lord, this IL and FS, my lord, who is the principal debtor, my lord, in the insolvency proceeding, my lord, both the plaintiff and the defendant's name are appearing as to be secured creditor. Now, my lord, that date really they intend to recover from us. Now, my lord, that my lord, document we also have annexed with my lord, our written statement.
My lord,
So, my lord, whether as the moratorium applies there, and they could not recover it from there, my lord, this should, my lord.
My lord, the plaintiff had separate commercial transaction with ILFS and also the defendant. And in the defendant, in their assets and liabilities, they have admitted our debt. It's not that we are supposed to.
Okay. So that's why now they have issued.
Yes, they have taken the
Have you
point.
gone through the issue number 3?
Yes, I've seen.
The first one, concealment, practically it is
Roger,
ILFS and
Roger,
admitted. Yes. Then is secured creditors.
Where? Page photo. My lord, if your lordship kindly takes up, my lord, their plaint, page 37.
Page
37.
Yes.
My lord kindly sees, my lord, this is annexure D. They are annexure. My lord kindly sees, my lord, Gopal Trading, and my lord, the beneficiary name
37.
37. My lord, it's a document by IL and FS of the plaint.
Of the plaint.
My lord, there is it is
37 is annexure H.
H.
37 is annexure H.
Plaint refer
That is
something
the
else.
Master, the Ministry of Home Corporate Affairs receipt.
Then, my lord, the pages are not telling. Annexure D, na? My lord,
Annexure D.
my learned friends, my lord, also.
My lord, it was amended, my lord.
Amended.
After the legal yes came into the step.
So this is amended?
Yes, this the amended it comes to annexure D.
Annexure D. ICICI Bank.
Yes.
Page 32.
Yes, that one. Now, my lord, lordship kindly sees, my lord. Payment advice by IL and FS. My lord has
Gopal Trading.
Yes. My lord, our debt is being directly paid by IL and FS because they were the ultimate beneficiary. And my lord, and if your lordship so pleases, we have annexed the document.
No, have you disclosed that?
Yes.
This document is in the written statement.
Yes, my lord, in my written statement, if your lordship kindly takes up. My lord, this is their document. After all, they are pleading also. They cannot deny. My lord, so far relevant document we are concerned, my lord kindly comes to page. My lord, 36 first. 36.
Gopal Trading.
Yes, my lord has been pleased to get that, my lord.
And in front.
And then 37, my lord kindly sees. 37, my lord, consignee, our name is appearing.
And in front.
And then, my lord, delivery address is, lordship kindly sees, my lord, SG Heavy Engineering Private Limited. That is, my lord, the fabricator of IL and FS. Now, if your lordship kindly comes to, my lord, page 82 once. Page 82. Now, my lord, page 82, that is, my lord, the insolvency proceeding, list of, my lord, creditors' liabilities. Page 82, my lord has been pleased to get that.
Yes.
288, serial number, lordship kindly sees. Gopal Trading.
288.
88.
Gopal Trading.
Gopal Trading. That is the claim against my lord IL and FS, out of which my lord 15,000 directly from IL and FS. My lord, our name is also there. My lord, at page 104.
Page 104.
With regard to the same date, my lord, serial number 791, NC Infracon.
$791. NC Infra.
NC, defendant. So plaintiff, defendant, same date, they could not get it, my lord, because of the moratorium, and that's why.
May I just place two documents, my lord? If your lordship kindly takes up the plaint once.
Okay, no problem. It's a issue.
Yes, issue.
No, I'm saying, my lord, because this will be for determination of your lordship. Page 15, annexure A. In the plaint, my lord.
Yes.
My lord, this is the purchase order issued by the defendant, my lord.
Gopal Trading.
Purchase order Infracom, my lord, issued by the defendant.
No,
and
page 15.
Page 15.
Page 15 tax invoice. of the plaint.
Yes.
Page 15 is the tax invoice.
The purchase order.
Again, Milord, probably Milord, that amended. That's why pages are not tallying.
Purchase order is page 10. Annexer A.
Yes, Malad. But that is by NC Infracom, Malad.
Income to
They
Gopal
have-
Trading.
Yes, Malad.
Same document I have shown to your lordship
Malad,
in the
if your
written
lordship
statement.
kindly
Next page.
takes up Annexer H, Malad.
Yes.
Annexer H, Malad. This is auditor's report, Malad, of the
Annexer
defendant. H, Malad.
That is the Ministry of Corporate
Yes,
Affairs.
yes, that is the receipt, Malad. The next page.
Ah.
If your lordship kindly comes to the next page.
This
is the independent auditor's report of the defendant, and Malad, it's the report starts. If your lordship kindly takes up the balance sheet, the current liabilities. Here the name of Gopal Trading, that is the plaintiff, it appears, and this amount matches with the amount that we have claimed in the plaint. They have admitted the liability. And this document they have not denied in their admission.
Have you filed the counter claim?
No.
So how the ISU 6 will come?
Counter claim petition नहीं है मुझे.
ISU 6 will not come. You're not counter claim is not there.
No.
Why the jurisdiction point? You have taken the jurisdiction point.
Because of Milord that moratorium and Milord.
moratorium.
Yes. Milord, I could have Milord on the point of law preferred an application, but Milord, it really requires initial trial and then Milord we can argue.
That's good. So I am taking the all 4 issue of the plaintiff and the defendants 1, 2, 3, 4, 5 and 8.
5 and 8.
5, 7 and 8.
Might. Only 6 is excluded.
6 has been excluded.
Might.
So and so appearing for the plaintiff.
Compensation, Milord, really in the form of cost I was, Milord. That it's a harassing litigation. That's
Appearing for the plaintiff.
not as a matter of
Appearing
damage.
for the defendant. Full stop. Both the parties have filed their suggested issues. Full stop. The defendant has also filed the affidavit of admission and denial document after serving the copy to the learned counsel for the plaintiff. Let the same be cut with the expert. After hearing the counsel for the parties, peruse the pleadings and the suggested issues. The following issues of the
Issue টা দাও নি, suggested issue আমাকে একটা copy দাও। আমি তো বুঝতেই পারছি না কি আছে। আমার একটা copy দাও।
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. The plaintiff is directed to file judge's brief of document by disclosing all the documents relied by the parties within a period of 4 weeks. 6 weeks. Full stop. After serving the copy to the learned counsel for the defendant, full stop. The plaintiff is directed to file the affidavit of evidence of the plaintiff witness within 2 weeks thereafter. Full stop. 6 to 8 weeks. List the matter. Give the date for witness action. 26 June. 26 June, 2 p.m. for witness action.
I'm great.
Grateful.
Yes. Lord, there was a framing of suggested issue. It is a matter where I am a government company Premises was under me and then they were
Hmm.
as a tenant.
Well, as far as my understanding goes, my lord, discovery and inspection is not complete, my lord. So without that, my lord, framing of issues will become a bit of a problem, my lord. If that could be completed and then, my lord, the issues be framed.
Lordship, kindly see, by letter dated 11th, may I hand over this letter to you?
Your Lordship, Your Lordship, may I make some submissions in this, Your Lordship? I am the advocate on record, Your Lordship. The order date 24th January, Your Lordship, entirely my
Next matter.
on myself, Your Lordship. The client is a bit of embarrassment, Your Lordship. Unconditional apology for not complying. If Your Lordship,
Mr. Dinda is
But I think he's in the next matter.
Oh, I'm in the next. I'm sorry. I saw OC 7.
Mr. Dinda, this is Mr. Dinda. This is item number 16, not 17.
I saw the code. I'm sorry.
And he wants to earn a fee in every matter.
No, he's very cautious so that the matter cannot be taken. Yes.
If your lordship kindly see, first I wrote a letter that what are
No,
the...
well, whether there is a direction.
Yes, there was a direction.
Yes, sir, there was a
By
direction.
which order?
Pursuant to that order.
2511.
Yes, lordship. Pursuant to that order.
Arrange for inspection of the document.
Lordship.
On 1312. Please confirm. Yes.
So then I said that I have not relied any document outside. This is all the document which you had, because that's why I wanted to give a small description of the suit. I said it is a public premises. I will initiate public recovery under Public Premises Occupancy Act. They filed a suit in City Civil Court stating that this act cannot be applicable to. I accepted that. Then I filed another suit here because commercial division, because the suit is more than 31 crore value and then commercial property. So I filed it. So I relied all the document of his which he relied in the suit. So I have annexed that, and it's a pure question of law that this has been terminated. I am entitled to take recovery of the possession and the mean profit since, and they are depositing the earlier rent month by month as well. So this is a small issue. So I wrote to them that I relied on all the document which you relied in the court bill. I have given a direction. Then lordship, he writes to me this letter. Hmm. 6-1 is this. He said that I will make a compilation of the document and I will send. And then lordship, I wrote this letter. So basically in my plaint, I have only given the document which were relied by. So in fact, there is no new document as such. So
my lord, if he doesn't want to discover or inspect any documents, I cannot stand in the way, my lord. My lord, kindly gives me 7 days time to for my discovery and inspection, my lord, and my lord, thereafter kindly keeps it for framing of issue, my lord.
For us, he is.
And my lord, kindly records he doesn't want to discover or inspect any documents.
Sir, he has to give a. I have said that the document which I have.
So how soon you will disclose the document?
And I'll disclose in 10 days, my lord.
Yes.
So far
10
as
days,
I
I will
all disclosed in the plaint.
No,
then he has
for-
to give
for
inspection. Then he has to give inspection.
You have disclosed the copy.
Now, lordship, the original. So regard to the original, I said these all documents are already in the code below which you filed.
Well, there is a process.
Whatever it may be, which
he
you
should know what the process
wanted to
is.
rely upon the document which you annex with the plaint, you have to disclose the original to the plaintiff and the to the defendant. The defendant will disclose the original to you. That's why for that way the inspection could be completed.
Lordship, before that, that's what I said. Before that, since these documents are already in the code below, if we use a affidavit of admission denial, then lordship, the burden will be lessened on both of the parties. So lordship, I would request your lordship to pass in direction for denial and admission, which they have so far not done.
First, we must disclose and inspect what documents we are going to see in the
Correct.
suit.
Admission and then that's why you are shy to disclose the original to the plaintiff. To disclose it and file the affidavit.
Extend them 7 days time to both of them.
So and so offering for the plaintiff, so and so offering for the defendant. Both the parties press for extension of time to complete the discovery and inspection of the document. Consider the submission made by the counsel for the parties, both the parties are directed to disclose their document for inspection and within 10 days from date. Full stop. After completion of the inspection, discovery and inspection of the
Lordship,
document.
kindly make it 14 days. She is
2 weeks, Guru. 2 weeks. After completion of the discovery and inspection of the document, parties are directed to file their affidavit of admission and denial document within a week.
within a week, Lordship.
Within a week. Within a week thereafter. Full stop. The parties are also directed to exchange the suggested issues.
Lordship, suggested issue, may I kindly note
After
that I
that,
have handled.
come on that day. Exchange the suggested issues.
My lord,
In the meantime.
my advocate on record is requesting one thing, my lord. There's a small long weekend in the middle, my lord, if it may be after that, my lord.
Yes.
My lord, after
Instead
this
of
long
14,
weekend,
they
that
have
is
gone to 18, Lordship. Same prayer was made by my advocate.
2 weeks.
very well. my
I
lord.
have given
Grateful.
2 weeks.
Grateful, my lord.
I have not fixed the time. I
Grateful.
fixed the 2 weeks.
2 weeks,
From
yes.
date. क्या बोला? And exchange the suggested issues. List the matter. क्या बोला? 3 weeks, 2 weeks. 2 weeks, 2 weeks, 1 week. 3 weeks. List the matter on 5th of May 2025 for framing of issues.
I'm deeply.
Very grateful, man.
Your Lordship, item number 17, before my learned
Now,
friend
Mr.
made
Dinda
some
will have
submissions.
something to say.
Yes, your Lordship, I completely understand, your Lordship. There is a gross non-compliance of an order passed by your Lordship. This is entirely my fault, your Lordship. The client has nothing to do, your Lordship. I just need 3 days. Without your leave, I cannot comply with the order, your Lordship. Everything is ready. I just need 3 days to comply with the order, your Lordship. I am unconditional apology for non-compliance of this, your Lordship. It is a bit of embarrassment, your Lordship. 3 days. Just 3 days, your Lordship. This is my fault. The client has nothing to do with it, your Lordship. This is my fault.
20,000 rupees paid.
Your Lordship, without the leave, I cannot pay, your Lordship. Just extend it for 3 days. I will comply within this Friday. Within this Friday, everything will be compliant.
So and suffering for the plaintiff, so and suffering for the defendant. Counsel for the plaintiff. Praise for extension of compliance of the praise for extension of time to compliance of the order to comply the order dated 24th January 2025. Consider the submission made by the counsel for the plaintiff. Plaintiff is granted 1 week time.
Your Lordship, more than enough, your Lordship. Everything is ready. I just need your Lordship's
Perhaps
leave.
will fall, my lord, between the only
Then
16 and
the
17
all
is available.
vacation 2 weeks
Your
time.
Lordship, let me show my bona fide by complying
Because
the
we
order.
all had also
order dated
lord, offered for inspection of our documents, my lord. They are not with us now, so we have to arrange for them.
So 2 weeks time I granted. 2 weeks time.
So grateful, your Lordship. So grateful.
24 January 2025. Full stop. This is the matter on 30th April 2025 for framing of issues.
So grateful, your Lordship. I'm extremely sorry for non-compliance.
If it not come by, then 20,000 will be double.
No, your Lordship. Everything is ready. I just needed your Lordship leave. So grateful, your Lordship.
Thank you.
Grateful.
I'm for the petitioner, Lordship. The matter was discovery inspection of the documents. We had served them notice to come and inspect our documents, but they have.
You are for the
petitioner, the plaintiff.
Yes. When you saw the notice,
We had served to hand over. This notice
reply.
was served. We had served them twice. On the
no
first,
reply.
on the first instance, they refused to receive it. They on over call, they spoke to my senior Sonal Shah, saying that there is some issue. Kindly keeps it on some other date. They'll discuss. Another time we again sent a notice, and they again said that they will not accept the same. At that time, we had sent it by email because they were not receiving the hand service. By email, we served it to them. They are not replying to our notices. Not appearing also. Last day also, they had not appeared.
So and suffering for the plaintiff. None appears on behalf of the defendant. By an order dated 6th of December 2024, this court directed the parties to complete the discovery and inspection of the document within 3 weeks and to file affidavit of admission and denial of the document within 2 weeks thereafter. The parties were also directed to exchange the suggested issues. And the matter was fixed on 21st of January 2025 for framing of issues. The matter was taken up for hearing on 24th of January 2025. On the said date also, None appears on behalf of the defendant. And for the interest of justice, time to complete the time to comply with the order dated 6th December 2024 was extended for the period of 3 weeks. Full stop. And the matter was fixed on 28th of February 2025 for framing of issues. Today, when the matter is taken up for hearing, none appears on behalf of the defendant. Counsel for the plaintiff has handed over 2 letters dated 21st of February 2025 and 27th of February 2025, requesting the defendant for inspection of the original document. But in spite of receipt of the said communication, the defendant have neither come forward for inspection of the original document of the plaintiff, nor the defendants have disclosed their document to the plaintiff for inspection. Let the communication be kept with the record. Give the copy.
There are no documents annexed to the written statement.
It is also fine from the record the defendant has not disclosed any document in the written statement. In view of the above, the discovery and inspection of the document by the defendant is closed. The plaintiff is directed to file the affidavit of admission and denial. There is no affidavit of admission from the plaintiff is directed to file the judge's brief of document within 3 weeks. Within 3 weeks, after serving the copy to the counsel for the defendant. The plaintiff is also directed to file the affidavit of evidence of the plaintiff witness number 1 within a week thereafter. List the matter, give the witness date. List the matter on 6th June 2025, 26th of June 2025 at 3 p.m. for witness action. Next.
Lordship, I beg to appear on behalf of the plaintiff. In compliance of your Lordship's order, we have given discovery inspection and they have also disclosed their document. But one difficulty is that since this is a change brief, your Lordship, while I was holding conference with my client, I saw some annexures have been labeled correctly, but some different documents have been annexed to the plaint. Now it's a commercial suit, your Lordship. I have to take out an appropriate application, your Lordship.
For what?
For bringing those documents, your Lordship. The difficulty is that those have been labeled correctly, but some different documents have been annexed to the plaint. For that, I have to make out an appropriate case for bringing in those documents. So kindly gives me some time so that I can file the application. Otherwise, we have complied with your Lordship's direction.
No, perhaps, my lord, compliance has not been done because if they want to take out an application, I can't send it, let them take out an application. But on 13th February, my lord, both parties met. We disclosed our documents. Our documents inspection is complete. I'm sure my learned friend won't contradict. Only complete. Only annexure A to the plaint says something in the body of the plaint, but the document is something else. The plaintiff tried to show us some other documents which we couldn't take inspection, of course. So annexure A, it's not complete insofar as the plaintiff's documents.
And the issue regarding the repudiation also. We had relied upon some documents, but those has not gone.
So the plaint, there's a discrepancy. The annexure is different from what is mentioned as the annexure in the plaint. So let them take out whatever application, my lord, will kindly adjourn the matter.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that the plaintiff has disclosed the document to the defendant, but at the time of disclosing of the original document, it was found that some of the documents which were annexed with the plaint is not matching with the original document which the plaintiff intend to rely upon. Accordingly, plaintiff pressed for time for taking appropriate steps. Counsel for the defendant submit the defendant has already disclosed their original document to the plaintiff and the plaintiff has completed the inspection of the document. What about your affidavit?
I have to file once the
in view of the above. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 7th May.
Grateful. I'm so grateful to you.
20, my lord, I am for the plaintiff, my lord. But in this matter, my lord had already, my lord, allowed the defendant to file their written statement.
On the
What about the appeal?
No, no appeal.
No appeal.
No appeal. Fortunately. Why fortunately? What unfortunate instance you have seen? Well,
So now what you want?
one minute. IAGA 4 is there is another application because after this WS, my lord, already given the direction relating to my lord, discovery inspection, other things, my lord. They have given me a letter stating my lord, letter is at page 5 of the new application that is appearing. GA4, my lord. My lord,
page number
5. My lord, that their address has been changed. So, my lord, we again need to bother your lordship for an amendment that is at page 6.
This is amendment application?
Yes, my lord, because the address has been
Only
changed.
address?
My lord, we have indicated at page 6.
Page 6.
My
Only
lord,
this?
the first, yes, the Mira corporate suits, that part should be deleted. And at the bottom, my lord, JSBA house 125.
Address is changed.
Yes, my lord, only
Not the
address.
name
No, nothing other. May that be allowed, my lord, and then the.
Objection?
I don't know, not at all. They are a letter only. Yes.
So suffering for the plaintiff, so suffering for the defendant. The plaintiff has filed the present application being GA Com 4 of 2025, praying for amendment in the cause title of the plaint. Counsel for the plaintiff submitted. The defendant has communicated a letter defendant by a communication dated 25th of February 2025 informed the plaintiff that the address of the defendant has been changed, and accordingly on receipt of the said communication, the plaintiff has filed the present application for correction of the address of the defendant in the cause title.
Incorporate, yes, madam.
Consider the submission made by the counsel for the plaintiff, peruse the proposed amendment. This court find
Prayer in terms of ABC of the master summary.
Consider the submission made by the counsel for the plaintiff, produce the proposed amendment. This court found that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer A to C,
my lord,
of the master summary is allowed. GA4 is disclosed.
Grateful, ma'am.
I'm asking for the defendant
Yes.
in the matter by your lordship's last order dated 20th of January 2025. Your lordship had directed the parties to exchange their suggested issues and to complete all the formalities in the meanwhile. Now, we had written to them immediately on the following day, served upon them the copy of the suggested issues, and we had even written them to give us inspection of the documents. They haven't yet given us the inspection of the documents, but in compliance of your lordship's order, we have made ready the affidavit of documents, the admission and denial, despite not having received the documents in original, and to take inspection, and then also affidavit in terms of Order 11, Rule 6.3, and the suggested issues. So may I be permitted to file all of them? I have already served a copy of each to my learned friend.
Yes. Lord, they have complied, but out of time. Beyond order time, my lord passed the order on 20th January, not within time. Now give me some time, Lord, to comply my part of the obligation.
We had complied it within time. 21st of January, I had written letter.
They have done.
We
Yeah,
have
but
done.
kindly give me-
I'm carrying all the correspondence.
Can you give me some time to comply, my lord?
How much time?
Lord, give me,
Commercial suit, sir.
Lord,
Their suit.
they have not offered the inspection till date.
No. They have to take inspection of our documents. I have given them the
1 week for
documents.
inspection. I'm not 1 week for framing issue. I'm not very brief 3 weeks. Very brief 3 weeks.
So how soon you will disclose your original document?
No, I have given the copy.
Copy will not
Last
do.
original
Original
should be
inspection
disclosed
has
for
to be
its,
given.
I will.
Copy
By
is
within a week.
record.
Within a week.
Within a week.
Yes.
And they have to also provide us with a copy of their suggested issues, which
Yes.
I have done.
Certainly, I will do that.
ये मैडम वो क्या फाइल हुआ दे दो so suffering for the plaintiff, so suffering for the defendant. Police department. Counsel for the plaintiff, counsel for the defendant has filed the notice to produce document, affidavit in terms of Order 11, Rule 6 within bracket 3 of the Code of Civil Procedure as amended under the Commercial Court Act 2015, affidavit in terms of order 11 rule 4 of the CPC as amended under Commercial Code Act 2015, affidavit of documents and the suggested issues. After serving the copy to the land counsel for the plaintiff, let the same be kept with the record. Police counsel for the plaintiff prays for extension of time to disclose their original document to the plaintiff for inspection. Accordingly, the plaintiff is directed to disclose their original document to the plaintiff within a week from date. Full stop. On disclosure of the said document, the defendant is directed to complete the inspection of the document within a week thereafter. Full stop. The plaintiff is also directed to supply the copy of the suggested issue to the learned counsel for the plaintiff in the meantime, to the defendant in the meantime. Full stop. And list the matter on
for admission denial by me 1 week thereafter.
The plaintiff is also directed to file the affidavit of admission and denial document within a week thereafter. List the matter on 5th of May 2025 for framing of issues.
Grateful.
Not by plaintiff, not by defendant. They have done it. By plaintiff.
Grateful.
Not, may I get a copy of their document to include in the paper book? They have not given a copy of the document. Their document.
Yes, we have given.
You have given list. You have given list.
No, we have.
If you are
given
not
the
received, give
entire-
the made a communication.
Yes, right, I will send it.
What
if
you
it's
want?
Not already sent. Grateful.
This matter, my lord, I'm for the plaintiff petitioner, my lord. Unlike the other matter, my lord, this matter, my lord, we had when the WS was allowed and client had instructed to test his luck in appeal, my lord. That's why I asked. So it was actually pointed out on the other day. What has happened? Man, the appeal is pending, my lord. On the other occasion, Honorable Justice, the bench is presided over by Honorable Justice Shoman Sen. So, man, they had asked for an adjournment. No, changed. Now presided over by Honorable Justice Orijit Banerjee, I believe. This matter is taking. But on 25th March, when the matter was taken up, they had requested us to take for an adjournment. So that is recorded. At their instance, adjournment was taken. But allow us 3 weeks' time. I believe everything will be wrapped up in the meantime. So you are for the? I'm for the plaintiff. So appearing for the plaintiff. None appears on behalf of the defendant. As per the prayer made by the counsel for the plaintiff submitted that the defendant have prepared an appeal. No, plaintiff has prepared an appeal against the order passed by this court dated. Against the order passed by this court wherein this court has extended, wherein this court has refused to accept, has extended the time, has accepted the written statement. Yes. Has accepted the written statement filed by the defendant. Full stop. Counsel for in view of the above, the counsel for the plaintiff submitted the appeal is pending and prayed for time. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 15th May. Yes, ma'am. 15th morning. Yes, ma'am. Next. The order is of November 12, 2024.
May it please your lordship, Millard, I am appearing on behalf of the plaintiff. Lordship's last direction, Millard, was for completion of discovery and inspection of documents. Millard, we have, on behalf of the plaintiff, offered inspection to defendants numbered 2A, 3 and 4. Millard, today, these defendants numbered 2A, 3 and 4 are supposed to, Millard, produce their documents for our inspection. With respect to defendant number 5, Millard, we have not offered inspection yet. We shall, Millard, be doing that. As if your lordship
you are appearing for?
Defendant number 5.
And you are for the one?
I appear for 2A.
1, 2A and 3 and 4.
Not 1, 2A, 3 and 4.
Who is appearing for the defendant number 1?
Millard, defendant number 1, Millard, is perhaps.
What is your good name, sir?
My name is Anindo Haldar.
Earlier you have appeared 1, 2A, 3 and 4. Now you are not appearing.
Millard, with regard to defendant number 1, I am not appearing.
Last occasion it is recorded.
It is recorded, sir.
Millard, that is a mistake. That is a mistake.
Okay.
But I only beseech, since the defendant number 5 is today represented, they were not represented on the last occasion. I only request my learned colleague Millard to cooperate with us when we call upon them for inspection.
I will do that. I am in default. I am not standing in the way.
File the written statement.
Yes,
Everyone has filed the written statement. Your lordship was pleased to record it in your
Defendant number 1 also filed. All are filed.
Defendant number 2A, 3 and 4 has filed.
These, Millard, are the appearing defendants.
1 is not. What about the 1?
My lord,
one is a partnership form, my lord.
Yes.
My lord, on the date of the one of the partner, my lord, the partnership got dissolved.
The others are there. 2A, 3, and 4 are there. Your lordship, my lord, may
So what is
extend.
the prayer now?
My lord, your lordship may extend time for discovery and inspection.
My lord, I have taken inspection of their documents.
They're not
Today they will inspect.
I have, my lord, disclosed my documents to 2A, 3, and 4.
For me, my lord, everything is pending. It's very candid, my lord. I am not.
So appearing for the plaintiff. So appearing for the defendant number 2A, 3 and 4. And so appearing for the defendant number 5. None appears on behalf of the defendant number 1. By an order dated 10th January 2025, it is found that this court has recorded an order wherein Mr. Sukanto Chakravarti appeared on behalf of the defendant number 1, but today it was informed that he had never appeared on behalf of the defendant number 1. Full stop. Counsel for the plaintiff submitted defendant number 2A, 3 and 4 already disclosed their document.
No, my lord, we have disclosed our documents to them.
Counsel for
They
the
will be
plaintiff has
disclosing today.
already disclosed the document to the defendant number 2A, 3 and 4 for inspection. Inspection completed.
Well, I have taken inspection of their documents. Today they are going to inspect my document.
Full stop. And the defendant number 2A and 3 and 4 have completed the inspection of document of the plaintiff. And the plaintiff will disclose his document in course of the day.
My lord, the plaintiff will inspect the documents of 2A, 3, and 4 in
Correct.
course of it.
You have disclosed? No.
Yes, today, my lord,
The
they will
counsel for the plaintiff will inspect the document of the defendant number 2A, 3 and 4 in course of the day.
Yes.
Full stop. Counsel for the defendant prays for extension of time to complete the discovery and inspection of the document. In view of the submission made by the counsel for the defendant number 5, the plaintiff is directed to disclose the document to the defendant number 5 within a week.
Yes, my lord. We have been calling upon them through letters.
And the
I hope
defendant number 5 is also directed to disclose their document within a week from date. Full stop. Both the parties are directed to complete their discovery and inspection of document within 2 weeks from date. Full stop. In the meantime, all the parties are also directed to exchange their suggested issues. Full stop. Now, in the parties are also directed to file their affidavit of admission and denial document within 2 weeks.
My lord, it would be 3 weeks, my lord, because
Within
2
3
weeks in
weeks.
between for inspection.
Within 3 weeks. Full stop. Within 3 weeks after the completion of the inspection of the document.
No, then
Within
that,
2
that
weeks.
will be 5 weeks.
Within 2 weeks. Within 2 weeks after completion of the inspection document. Okay. Full stop. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 8th May 2025 for framing of issues.
So 1 week, it will be 2 weeks for me to disclose because my clients are in Delhi.
But this I'm objecting. We have been requesting him for very long. January 10.
I'm just requesting for it.
Next.
Obliged.
For the defendant. Your lordship, my lord, on the last day.
My lord, I am appearing for the plaintiff, my lord, in this matter, my lord.
Yes.
My lord, we have filed the suggested issues, but there is one difficulty I think my learned friend will also be aware of regarding the inspection.
Yes.
My lord, there are certain documents when we went for inspection, they asked us to inspect the documents from their computer, soft copies.
Emails.
But yes,
Actual documents are the computer.
no, but those emails are not included in the list of documents which are filed along with the written statement. I have an obligation to inspect only the documents which have been mentioned in the list of documents appended to the written statement. If suppose each document has an attachment by way of an email, that also has to be part of the written statement list of documents.
Correct.
Today, my learned friend at the time of inspection says all these correspondences have been exchanged by mail. So you take inspection from my computer. How is that possible? So how will when the suit comes up for hearing, how will the court take note of those emails? So that is why we have given by way of a letter, we said that we are in a position to inspect only those documents which are in the list of documents appended to the written statement. And we have not inspected those soft copies of the emails which are in their computers. Now, this is the position with regard to inspection. Otherwise, everything has been done.
But insofar as the emails are concerned, if your lordship has my list of documents filed along with the plaint, but I have given the particulars of
You
the
are for
document.
the plaintiff.
Yes,
No.
no, I'm for the defendant. I have a counterclaim, but I am for the defendant.
You're disclosing the written statement.
Yes, in my
Where
written
is the
statement.
written statement?
Okay. But my list of documents affidavit is being handed over to your lordship. But at that, if your lordship kindly takes page 2, the particulars of the documents are given. On the left-hand side, details of the documents and parties. Lordship has seen. I'm sorry.
Where?
But my list of documents. Affirmed. It's not affirmed.
12th April.
But it's not affirmed. It's by the advocate. Will your lordship has my copy? Must be there in your lordship's copy as well. List of documents as per order 11.
Yes.
The chart. Yes, in the list of documents, lordship will see details of the documents are given on the left-hand side. Annexure A, copies of the weekly reports. Annexure B, so and so. On the column, where mode of execution, issuance, or receipt. If your lordship sees on the third, on the right-hand side, third column. Mode of execution.
Mode of execution on
Yes.
the issuance of receipt.
Yes, these are all by emails. I've mentioned that.
Correct.
So, at the time of inspection, I have given inspection of the documents which are annexed to the written statement, as well as the documents through which these documents were exchanged between the parties. These are inter-party emails. So, it's not that I have not mentioned that these were communicated or exchanged by way of email. I've mentioned that. But those are we had given printouts of the emails. The learned advocate said that no, these are not originals. So emails have to be on the computers. And then we disclose the computer as well, where the emails are stored. These are inter-party emails. It's not that these are third-party documents.
Mr. Sen, I will direct whatever the document relied by the defendant in page number 29 of the written statement that will be given. If it is the mail, the copy may be given with admission of that document will be decided at the time of evidence because they have to prove it.
Absolutely, but only one thing, my lord.
Suppose,
suppose I take inspection from their computer.
Correct.
Point
That is not the way for computer. What the document they relied upon, let they inform you. This is all the email. So naturally, you cannot take the original copy. You cannot inspect the original copy.
That is number one. But my other point is, my lord, that your lordship can keep it open and decide later whether those emails, which are not forming part of this written statement, can at all be looked into.
Correct. That's why I'm asking with regard to the list of documents as mentioned in page 29 of the written statement.
Yes, I have no objection about that.
But page 29, that is at the time of evidence. If they will go beyond that, that will not be taken on evidence.
That is my submission.
In order to regularize that is why we said that since we have mentioned that these documents were exchanged through emails, we are producing the emails as well.
No,
documents have already been disclosed.
So what I propose, leave all the controversy. I will direct to you the copy of all the document by disclosing.
That's already been disclosed. That's inspected.
That's
inspected. So they want us to inspect the emails which are also not part of this written statement.
No, that's why I'm asking. I am giving a proper direction. You disclose again with regard to this document within a week.
Only these documents.
The list of documents says that mode of execution is by email. So, that is why I'm producing the emails as well.
What I propose, leave aside all these things. You disclose all the document by a letter. This all the email document. Yes. Naturally, so email document he cannot ask for the original document.
Yes.
So you have to prove your email
in evidence.
In evidence. Electronic document in evidence. You prove it of your own.
Well, if at all, that is already part of the written statement. Your lordship will keep it open.
No, that I am not asking. That is at the time of evidence.
Yes.
Only that's why I'm asking. That's why I'm passing an order with regard to the list of documents as mentioned in page 29 of the written statement.
Along with
Yes.
the documents through which those documents were shared, that I'll be able to prove in trial.
So appearing for the plaintiff, so appearing for the defendant. By an order dated 17th of December 2024, this court directed the parties to complete the discovery and inspection of the document. Full stop. Counsel for the defendant submits that. Counsel for the plaintiff. You have the defendant.
I for the defendant.
Counsel for the plaintiff submit that the defendant has disclosed the document and requested the plaintiff to inspect the original document, that is the emails from their computer.
As well as printouts.
Right.
Printouts were also given.
From their computer and the printout documents. Full stop. Counsel for the plaintiffs, submit that the plaintiff
At that time, printouts were not given. They only told us to inspect from the.
Because they were there,
Counsel for the
because of their
plaintiff submits
opposition, that they will not look into things.
if the plaintiff will inspect the documents from their computer, that is the email, the plaintiff will not be in a position to see whether the attached document in the mail have been disclosed by the defendant in the written statement, due to which the plaintiff has not inspected the said document.
May I interrupt once? It is the other way around. They said that the attached documents are disclosed, but the emails are not disclosed. That is why they will not inspect.
In view of the above, this court direct the defendant to disclose the copy of all the documents as mentioned in the list of documents relied by the defendant at page number 29 of the written statement to the plaintiff within a period of 1 week from date. If all the documents are the emails, it is not, it is it is upon the plaintiff, it is upon the defendant to prove the said emails during the evidence. During the evidence. Full stop. If the defendant disclosed the said documents, that is list of documents mentioned in page number 29 of the written statement to the plaintiff within a week from date, the plaintiff will complete the inspection of the document within a week thereafter, and full stop. The parties are directed to file their affidavit of admission and denial of document within 2 weeks.
2 weeks. 2 weeks.
Thereafter, full stop. In the meantime, the parties are also directed to complete the exchange the suggested issues. Full stop. List the matter on 13th of May 2025 for framing of issues.
Your
This you have
lordship,
filed today?
No, this is filed earlier with the
in
written
that regard, the interim order may be extended.
Which order? By which order the interim order was there? When the last interim order was extended?
Definitely, I don't think there is any interim order.
order.
No. This is the suit which has come. Kindly excuse my learned junior. But only one thing, if your lordship may provide
your
that
lordship.
this is without prejudice to the plaintiff's contention.
If any of the parties relied upon the email documents, email copy of the documents, that will be subject to proof by the parties during evidence. That's
Exactly.
all.
Yes. Oblige, Your Honor.
Oblige.
आंसर कोई है पार्टी है
Lord, I appear for, I'm the receiver, my lord, in this matter. Your lordship, I'm filing my original report, my lord.
Yes.
Your lordship, may kindly see, is February 28, my lord, I was appointed. Lord, may kindly straight away turns to paragraph 16 of the report, my lord.
Symbolic possession.
Yes, my lord. So, my lord, there are, my lord, 5 properties are concerned, including bank accounts. First property, my lord, I have already taken symbolic possession and I have made the inventory. Inventory, my lord, consists of the residential items, which is bed, sofa, TV, and all these.
Who is allowed to enter into the bedroom?
Your Lordship has only given me liberty to take inventory of the residential flat. Second is, my lord, serial number 2 is the office, which is already under padlock. I don't know, my lord, by whom I had asked, my lord, from the relevant people, but my lord, I have pasted the notice of the symbolic possession. Third is the, my lord, flat, which is at the, my lord, Hemanto Basu Sarani. My lord, this flat, my lord, does not, this flat has already been sold to Rajeshri Lahiri by SBI. It's not in the name of defendant. Fourth, my lord, flat, there is no such flat, though there is a deed. But I don't know how this
What?
flat, in serial number 4, my lord,
Symbolic possession could not be taken as
because there is no such
Plot
flat,
at
but
the
there is a
premises
registered deed in respect of flat 4. So
the deed is there. There's
only,
no flat.
but there's no flat.
Okay.
And my lord, fifth, my lord, bank account maintained at Federal Bank Gultadanga branch. There is a balance of ₹1. And my lord, the bank account is, my lord, centrally debit free. So far as bank account is Bombay is concerned, there is no details. Which branch, which is the account number. So my lord, nothing could be done as regards this is concerned.
Yes.
My lord, I have given them the copy, my lord, of this. Your lordship had
Defendants
asked.
were not present at the time of the transaction.
Whom, lord?
Defendants were not
Lord,
present.
defendants,
Nobody
lord, in the
said.
residential flats, the directors were there, but in other properties, they were not there.
Not there.
And lord, I've annexed the photographs where I've taken possession.
Yes,
Lord, just
sir.
one thing, your lordship, in February 28, your lordship had revised the directions in 25th of March, wherein these properties were included.
Yes. Okay, you go through the report.
I've already intimated them.
One mallet direction I need, mallet.
Mumbai Bank.
Regard to serial number 4.
Serial number 4 of the report.
Yes.
Paragraph 16, my lord, paragraph 16.
There is a registered deed. Now, the registered deed is there, but the flat is not there. But for that, mallet, I think, mallet, an inquiry would be necessary. That because it's a registered deed by the registry.
In that case, who is here the authority? District magistrate or the revenue?
Registrar of assurance.
No, registrar of insurance registered. But with regard to the property, who is the revenue officer? Who in the
assessing.
First of all, disclose that deed. That deed is not before the court. It will be
Registrar of assurance, he is registering the document in terms of the document produced by the parties. But with regard to the identification of the property is to be done by the Tehsildar. Whether the Tehsildar put is in here, no. Who is the authority here in Calcutta, West Bengal?
Already that even, mallet, it gives me a, mallet, keeps it day after tomorrow. I'll take the necessary.
You take that also, and with regard to the bank account of the Bombay branch, IDFC.
Yes,
You
and
take
the,
this.
and the other properties he can take physical possession.
If they will not come. Remuneration paid?
Yes, my lord. Lord, other properties should have
Sense suffering for the plaintiff. None appears on behalf of the defendant. The receiver is special officer. What?
Lord, special officer.
The special officer is also present and filed report. After serving the copy to the learned counsel for the plaintiff, let the same be kept with the record. Counsel for the plaintiff prays for time to take appropriate steps. With regard to flat number 4 lying on the second floor at the southwestern side, having super built up area of 2000 square feet. As per the report of the
my lord, may kindly, my lord, mentions the address at page paragraph 15. I've only mentioned the flat number, but the address is P499 Hemanto Mukherjee, sir.
क्या बोला ऊपर बोला? With regard to at P-499, Hemanto Mukherjee Sarani, Kolkata 700029. Full stop. As well as the details of the bank account of the defendant maintained at HDFC Bank, Bombay. In view of the submission made by the counsel from the police, the report submitted by the special officer be kept with the record. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear. How much time? 1 week. We'll come back, my lord, I think day after tomorrow. Let the matter appear on 10th of April 2024. I will not discharge you.
Yes,
Because for physical possession, he'll be grateful. Next.
My lord, I appear for the
I will
plaintiff.
appear for the defendant, your lordship. The discovery and inspection is not yet completed. Lordship would kindly
Inspection
grant me
has been
some
taken
time.
of my documents. I have
Yes, your
offered the inspection and inspection has been taken of the plaintiff's documents.
Yes.
Defendant's documents yet not
You are for the
complete.
defendant.
I am
I
for
am
the
for the
plaintiff.
defendant. My learned friend is for the plaintiff. Lordship would kindly
You are
grant
for
me.
the defendant.
I am for the defendant, your lordship. In this
I am
matter.
for the plaintiff. My lord, the order has gone down. I haven't checked.
Rob.
Possibly because my learned friend has a counterclaim which is above my claim value. Possibly my lord's court officer has decided that he is the plaintiff. Counterclaim is more than my
My
claim.
court officer is not so intelligent to go by the claim.
There
No,
may have
no,
been
no.
some typographical error.
Some
your lordship.
typographical error.
Lordship
But
would
I will
kindly
accept
grant me some time. It may appear under the heading for case management. We shall file our affidavits in the meantime.
Sense appearing for the plaintiff, sense appearing for the defendant. Concept. What has happened in the division bench order? What?
Yes, that was Muller arising. Muller had already allowed my application as to security. That was carried up in appeal by the division bench. The amount was reduced by 13 lakhs. My lord had ordered 13.
Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the party. Counsel for the plaintiff.
My lord, it's the defendant.
Or the parties jointly. Your
Defendant, I have given inspection. My lord, I have this.
Counsel for the defendant prays for time to and prays for extension of time to complete the discovery and inspection with document. In view of the submission made by the counsel for the defendant, time to complete the inspection of the document is extended for a period of 2 weeks.
Lordship, there's 1 week that is the festival week. Lordship grants me 3 weeks time.
3 weeks. Full stop. Affidavit of admission and denial of document be filed within 2 weeks thereafter.
Yes.
Full stop. In the meantime, the parties are also directed to
exchange the issues.
Exchange the suggested issues. List the matter. 3 to 5 हो गया ना?
Lordship would list it for the case management hearing under the heading case management.
Framing of issues.
Very well.
Case management already passed the note.
Very well.
Oh, yes, case management hearing, that would be correct. Case management hearing. Because that is the Commercial Courts Act.
Let the matter appear under the heading case management on 22nd May.
My lord, may I find my affidavit of documents? We have that ready.
Come on that day.
Grateful, your lordship.
Grateful.
Obliged.
Lordship, in this matter, I'm appearing for the defendant.
I am
Your
appearing
Lordship,
on behalf of the plaintiff.
Inspection and discovery is completed for both the parties, Your Lordship. The plaintiff is yet to file its affidavit of admission and denial. As per the last order, Your Lordship, that sought for leave, we have still not received it.
Yes.
I am handing over copy. It has been filed in the department of 1st April, Miller.
The copy
has not been given.
Lordship, further, if I may, Lordship, this suit has been transferred to the commercial division for more than a year now. There is no statement of truth or disclosure of documents to that effect.
Statement of truth, possibly there is some misunderstanding, my lord, because in the order dated 26th April 2024, it has been recorded that statement of truth along with Wakalatnama is filed on behalf of the plaintiff. 26th April 2024. Original ta dao. Original ta dao. Copy dao.
Statement of truth is filed on behalf of the defendant. Let the same be kept with the record. Affidavit of admission and denial of the defendant. Statement of truth.
Well, I do not know whether that is on record because
it is there.
There is in our record there is a subsequent
statement
of truth on behalf of the plaintiff.
One is admission and denial of the document of the defendant, and statement of truth affirmed by Arun Bhaumik.
No.
It is
That is my statement of truth of the defendant.
It is not recorded who has filed. And list of document under who has filed this.
Disclosure of the defendant, Your Lordship. We also do not have any compliance documents of the plaintiff.
This is also all defendants.
Well, we have in our record, my lord, it has been affirmed on 17th October 2024, my lord. This may be kept on record, my lord. I give you handing over.
Affidavit of Manoj Kumar.
Affidavit of Manoj Kumar, my lord.
Dated
17th October
2024.
Yes, my lord. So that is already on record, my
It
lord.
is there. But it is some big one. We are having only 2 page. It is having the 9-10 page.
I do not know, my lord.
This is admission and denial of the document.
That is the admission and denial. This is the statement of truth, my lord.
The statement of truth is not here.
My lord. হয়ে গেছে দুটোই
হয়ে গেছে ডিসক্লোজার নেই
কোন ডিসক্লোজার
লর্ডশিপ
করতে দিলাম এক্ষুনি
এটা affidavit of admission and denial statement of truth no disclose order 11 compliance as per the commercial code section.
That is where you mention statement of truth.
not mentioned, my lord.
Even in the reading also not mentioned. It will be again, it will be problem.
Your lordship, the list of documents in terms of order 11 is also not there.
Oh, correct. No, they have filed the affidavit. This is filed. They have again, they have not mentioned order.
Today, your lordship, for the first time, I received a copy of the statement of truth.
That
If
your
you
lordship
go through.
My let's will kindly allow the advocate record to correct them by
Yes,
hand,
if-
my lord, and label them properly.
Even affidavit of document also, it is not the affidavit of admission and denial order 11 rules 4 subclause 6 or whatever it may be.
This is the admission of document.
But there is no kindly come to the back page.
This one.
As per order 11, find a separate list of documents.
You do one thing, I am giving liberty to either you file a fresh or you may correct this. What you suggest?
No, my lord. What my learned friend is telling me that there has to be a separate affidavit of
Correct.
documents. Other than this.
Other than this, there is a separate affidavit of document. This is admission and denial
Order 11,
document. There is separate affidavit of document. Then statement of truth and all these things in the back page. You have to mention what is this.
Yes, ma'am. Well, affidavit of document, I do not know if it has been filed because this was a
not
old
here.
suit, my lord.
It is not here. Yes, it is. Statement of truth of under order. Punjabi Singh.
Lordship, that was for the defendant, Punjabi Singh.
Tilak Raj.
Tilak Raj is for the plaintiff, my lord.
It is affidavit of document, I think so. See this.
Your lordship, if I may, this is the affidavit of documents for the purpose of the suit. Since after the transfer of the suit to the commercial division, there has to be a list of
No,
documents in terms
the
of order.
commercial number is not there.
Yes, my lord, the commercial number is there. This is the affidavit of documents that they had given for the purpose of carrying out the discovery inspection. Your lordship, for the purpose of compliance in terms of the Commercial Codes Act, that is not there.
Let's see. That's why they have to clarify.
My lord. Well, I also have to look into whether under Commercial Code Act in pending suits.
It is
Yes,
required.
it is compulsory.
Pending suit, if it is transferred, then you have to comply with the all provisions. And written statement, unless there is if you not file the written statement, unless there is a order of the court.
Right.
Otherwise, written statement is closed and you have to comply with all the document. Namely, with regard to the written statement, then you have to satisfy the court. You have not filed the written, then the court will consider.
Right.
And with regard to the all formalities, you have to comply with all formalities.
Then, my lord,
amended the plaint. Plaint is amended.
plaint not amended possibly, my lord.
Commercial division. No.
It is
Commercial
amended.
division, I will serve the copy to the other side.
No.
After amendment, no.
Again, it will be problem. We have amended only this portion. You have not amended in the original plaint in the first page of the plaint. Then
Liberty may be granted to.
Your lordship may fix a timeline for my learned senior to complete his compliance in terms of the Commercial Codes Act. Thereafter, we'll come back with the suggested issues, your lordship.
अनुतोष सब करता कौन है? ये तो यहाँ करके छोड़ दिया. मेन तो उसको यहाँ करना है. By which order it was transferred?
Transfer order signal.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. It is fine from the record. The suit is transferred from the original ordinary civil jurisdiction to this court as the dispute between the parties are commercial in nature. The plaintiff has filed the statement of truth as well as affidavit of admission and denial of document, but both are not in format. The plaintiff has also not filed the affidavit of document. It is also found that only after the transfer of the suit, only in the back page, it was recorded as commercial division in the cost title, but in the plaint, in the cost title of ना cost में आ गया है it is ऊपर वाला काट दो full stop. In view of the above, the counsel for the plaintiff press for time to file statement of truth, affidavit of document and affidavit of admission and denial document within.
Well, if not already filed and if
in
it is
format as per
my lord.
in accordance with in format within a period of 2 weeks.
No, my lord, because the officers are in Delhi, my lord.
Within a period of 4 weeks from date after serving the copy to the learned counsel for the plaintiff.
Lordship, the copy of the amended plaint as well.
The plaintiff is also directed to serve the copy of the amended plaint to the learned counsel for the defendant within 4 weeks from date. Full stop. The issues framed, no.
Lordship, no.
The parties are also directed to exchange the suggested issues in the meantime. Please the matter on 15th May 2025 for framing of issues.
Grateful, Your Lordship.
With regard to 27, Your Lordship. Next matter, Your Lordship. Your Lordship will for framing of issues, Your Lordship.
Who is the other side?
The other side is here.
Left for lunch.
Lunch. Early lunch.
Who is for the defendant number 2? Yes.
My lord, I understand lordship had some clarification, lordship, because this matter was otherwise heard. So it had this is there because of it was initially appeared as to be mentioned, then it has come because lordship one. Well, this is
that one. Yeah. Yes.
section 8 application.
Correct.
They had five,
Correct,
not
correct.
section 8, order 7, rule 11 application. But in essence, what they had argued was, my lord, that there is an arbitration clause and a forum selection clause. And to that, my lord, my response was that the arbitration clause and the clause which they are citing, that is not the subject matter of this contract, but it's a subject matter of a subsequent contract of 2021. So therefore, that doesn't apply. This contract had an arbitration clause which had a condition precedent that a dispute resolution board had to be constituted within a certain time. And it's an admitted position that the dispute resolution board was not there. And paragraph 41 of the plaint, my lord, says that why it is not there. Therefore, it is this clause can't be, it is not covered. And my lord, they have not invoked this clause, my lord, so far as this is concerned. Right.
Yes. In the morning he have mentioned for adjournment.
This is only for clarification. Hearing was over. In fact, lordship had dictated order. Lordship had dictated the
I
order
dictated
also
the order.
while correcting some
Some
clarification, lordship
clarification was
wanted.
required. Then I fixed. Then they have taken time. नहीं है.
That in fact, the main suit can be taken up by your lordship.
वो नहीं कर रहे.
One morning they are asking me regarding their.
So when he will be available?
I am dependent on one. I'm not dependent on two.
They are for the bank. The main, my lord. In fact, in the suit, my lord, the summons was served in August. And my lord, they have not filed. Defendant 2 has not filed any written statement. This being a commercial suit, my lord, it can be proceeded with.
Have you received the copy in that report?
Yes. My lord, I shall.
Yes, Lord.
But I
Yes,
think
Lordship.
Yes.
Yes, Lordship. Yes, Lordship. In this item, hello, am I audible?
Yes.
Yes, Lord. Yes, in the item, I have some personal difficulty. That I in the morning made a request to Lordship.
When?
The main commercial deposit.
No, you're not audible. Your voice is not clear.
Hello, Lordship. Hello. Hello. Yes, Lordship.
Yes.
Yes, Lordship. We have a written statement. We filed statement with a cost imposed upon us of 5,000. Then deposited by the advocate on board a check that has been cleared. Lordship.
That check is dishonored.
No, we have, again that local council taken care of the fact that it will be positive. It has been cleared.
Sense appearing for the plaintiff. Sense appearing for the defendant number 1. Defendant number 2 is appearing through virtual mode, but due to some technical defects in the virtual mode, the counsel for the defendant number 2 is not in person to argue the matter. And as such, the case is adjourned. Police interim order is still today.
Yes, my lord. Interim order.
Counsel for the plaintiff submit the interim order granted Delhi is expiring today and prays for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted Delhi is extended till 8th of May 2025 or until further order, whichever is earlier.
Lordship, it can be placed in the month of July.
July commercial suit.
But I'll get the suit heard before that, my lord.
Lordship, they have their they have already been the
What
stay
has-
order is
what
ongoing
has
and
what has happened to your written statement?
Lordship, we have filed a written statement.
No, but
and
about the your 5,000 rupees? The check was dishonored. Then what has happened?
Then we have filed. I have asked to the local council, and he has deposited, and it was duly been cleared from his. I just sent the local council to the registry and make the verification that it has been deposited by us.
Nobody's here.
So about the representing dependent number 2,
Ah.
above the land advocate Tanuj Gupta, Lordship.
Yes.
Lordship, the check, the.
Where is the report?
Lordship, yet I did not come with the report.
Huh?
Today I am not come with the report. Lordship,
Department, in the department, there is no written statement, madam. Right.
so deposited the money. The money. That was-
Today morning, how will it happen? Today morning, it will not. It's a commercial suit. If you have not filed it, my lord, let a report be called for so far as that is concerned. Because my learned friend here informs it has been filed today morning. Commercial suit time is up.
No, Lordship, it has been filed. TI temporary injunction reply has
You filed the written
sent via
statement.
through.
Lordship, we paid the amount.
Yes, Lord.
Have you filed a written statement
Yeah,
in terms
yes.
of the 23rd December?
See, in this matter, I have to instruct her.
And no copy has been served upon me either.
क्या बोला? Adjourn. Counsel for the plaintiff prays for extension of the interim order. Accordingly, interim order is extended till 8th May or until further order. Full stop. The department is directed to submit report whether the defendant number 2 has filed written statement or not. Full stop. The State Legal Service Authority, and the Secretary, Calcutta High Court Legal Service Committee is directed to submit report whether the defendant number 2 has paid the cost of rupees 5,000 or not. Let the report be filed by 8th of May 2025. This is the matter on 8th May.
Paid the money.
Report आ जाएगा. Lordship.
8th May 2025.
8 May.
Wait for this.
Yes.
I'm for the defendant, Lordship.
Item? Yes. Framing of issues.
Copy. I don't know what their issue is, Lordship. They have not
What
been
is
served.
this is a plaint?
This is the plaint, Lordship.
Where is the written statement? How many
Lordship,
how many volume the written statement?
Volume is very less. Lordship.
Volume is less.
Only difficulty, Lordship, what I find from the record, I don't think so they have complied with the Commercial Codes Act's norms, Lordship. They have not filed their affidavit.
Statement
And
of
other
truth.
things. No, I don't think
I'll
so,
take
Lordship.
instructions on that, Your Lordship. As per the
Because
instructions,
none
I
of
have
the
has
order,
been complied.
none of the order, again, Lordship, it is, we have filed it in 2004,
They have
February.
already taken many adjournments, Your Lordship, on this
Lordship,
pretext.
the compliance was
Yeah,
to
उसमें
be
देखो
done in
affidavit,
February
statement of truth
2024.
है. Let me sort it out this problem. Affidavit of statement of truth है. Affidavit document है. सब है. कौन फाइल किया? Plaintiff की defendant.
This is filed by the plaintiffs, Lordship.
H.N. Datta.
Lordship, we.
You are the plaintiff.
Lordship.
So you filed the statement of truth.
Yes, Lordship. In the month of February
They have
2024.
taken like many adjournments to comply with
How
this, Your
does
Lordship.
it comes into the
So
way
now-
of filing it?
Let me see. Let me see. So these are all plaintiff.
Lordship, all the things are from the plaintiff.
Affidavit of admission and denial. Yes.
And
What about you?
Your lordship gives me today, your lordship, I'll comply.
For
today.
Yeah, I'll comply.
When the case was transferred?
I think, Your Lordship, in the month of in December, perhaps, Your Lordship. December 2023, Your Lordship.
No, yes, 16
Yes,
May 22,
yes.
accommodation is sought for so and so for taking steps in commercial division. Case is adjourned. Affidavit admission denial filed. Just before document are yet to be filed.
We have filed our state admission denial also, Your Lordship.
We have also filed, your lordship. Then, your lordship,
No, nothing is
I'll
there
give
in that.
instructions on that, your
For
lordship.
what?
For complying with the Commercial Codes Act, your lordship.
Time is
Client
over.
will not. Client.
Time is over.
Yes, your lordship.
2023 case was transferred here.
Thereafter, they took many adjournments, your lordship.
They
for
might do,
complying.
but they filed it.
Yes, yes, your lordship.
But
They
you are not filed.
then kindly gives
Lordship, on
3 week time,
7th
your lordship.
March, on 7th March 2024, it was transferred. We have filed it on 18th
where is the
May
suggested
2020.
issues?
Lordship, we have filed it the suggested.
We have also filed, your lordship.
The WS has filed. All the respondents has also not filed their WSL or written state.
So it is independent. Going
For
undefended.
2, 3, Lordship, they have
For
not
appearing
filed.
for whom?
Eastern Coalfields.
Eastern Cold.
And others, we don't know.
Coal India?
No, your lordship. Only
You're
Eastern
not
Coal.
appearing for Coal India. So you are appearing for whom? Western Cold.
Coal India, your lordship.
Defend number 1.
Yes.
And for others, 7, 4, 5, 6.
All are the Coal India.
They are the subsidiaries, Your Lordship.
You are not appearing for the others.
Oh, all, your lordship, all.
All. Let me see the written statement.
Written statement is filed only by the defendant number 1, 7, 4, 5, 6, Your Lordship. 1, 5, 1, 4, 5, 6, 7.
6.
2 and 3, they have not filed it.
Five. 4. Yes. 1, 4, 5, 6. 1, 4, 5, 6.
Yes, sir.
What
2 and
about the
3,
other?
2 and 3, they have not filed, Your Lordship. But the wakalatnamas were perhaps filed by them for on behalf of 2 and 3 also.
7 is also filed.
Yes, yes.
1, 4.
1, 4, 5, 6, 7.
7.
Lordship. Document. Document number below 3. होगा कि तो WSO फाइट कर सकते
So your 7, 8, 9 are overlapping of the plaintiff's 4. Plaintiff is entitled to the claims as claimed in the suit from the defendants.
Oh,
Correct. So
yes.
it has come total.
I don't know what they have given also. I don't have a copy.
You're not given the copy?
Yes.
Copy.
This is it. Even
We are sharing it. Lordship will have it. We'll share it.
7, 8, 9 I am not taking because you already taken on that. Others are, oh, it's okay.
So our Lordship 4 is taking it.
You are all taking.
Lodge.
You are all.
Lodge.
There 6, 7, 8, 9 I am not taking because it is overlapping.
Lodge.
So and so appearing for the plaintiff, so and so appearing for the defendant. Both the parties have filed their suggested issues. Let the same be kept with the record. At the learned counsel for the parties, peruse the plaint, peruse the pleadings and the suggested issues. Also, the following issues are framed. This 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Okay. The plaintiff is directed to file the judge's brief of document.
It's already filed.
Right.
We have filed.
The plaintiff is directed to file the affidavit of evidence.
We have
Today
already
you have filed
filed. We have already filed.
what?
Judge's
Affidavit of
brief
evidence.
documents, affidavit of list of documents.
Affidavit of evidence.
Affidavit of.
So you filed the judge's brief of document today?
No, it is
Last
filed long
occasion.
back.
Okay.
27 November, Your Lordship, it is.
The plaintiff is directed to file the affidavit of evidence of the plaintiff witness number 1 within 4 weeks. 2 weeks.
Lordship will give some 4 weeks because
4
client is outstationed, Your Lordship.
4 weeks after serving the copy to the learned counsel for the defendants. Let the matter appear. Give the date for witness action. 30 June for witness action. At 2 p.m. Bring the witness.
I will talk. Yes, they are outstation, Your Lordship.
30 June. That's why I fixed at 2 p.m. Next.
Number 28, I appear for the
Lords, I appear on behalf of the defendant. Lordship's last order is 7th January 2025, my lord. After that, my lord, on 6th February, the plaintiffs had sat across the table and attempted to mediate, my lord. Now, my lord, the terms of settlement was entered into. The minutes of the meeting was prepared and we had agreed that till December 2025, we'll be making payments in installments. But my lords, now it has come to our notice. I have instructions that on 9th April, they are once again sitting for a settlement talk. And we hope that in the months to come, it will be settled. My lords, which is why, my lords, no exchange has happened yet. No affidavit of admission and denial or documents discovery inspection, nothing has happened because we are hopeful that the settlement will go through.
So appearing for the plaintiff. Yes.
But I was saying that if your lordship kindly keeps the matter after a particular date and direct that in case settlement does not happen, then we shall take step.
Correct.
So otherwise, when the defendant is not taking inspection, we have asked them
for the defendant. Full stop. Counsel for the defendant submit that, and this submit that the settlement with the talk of settlement between the parties is in process and there is chance for settlement of the matter and due to which the discovery and inspection of the document could not be completed. Full stop. In view of the submission made by the counsel for the defendant, the case is adjourned. Let the matter appear on.
My lord, if your lordship so pleases, sometime in May, my lord, because I'll just tell you, lord.
8th May.
Very well, lord.
On 8th May 2025.
Any day apart from 8th May.
It is made clear that by that time, if the parties have settled the matter, the parties are directed to come with the terms of settlement. If the parties fail to settle their dispute, comma, the parties are directed to complete their discovery and inspection in document.
Milord, any day apart from 8th May, Milord, 9th May.
13 can do.
I'm grateful, Milord.
9th is a holiday.
It's Saturday.
Discovery and inspection will document in the meantime and to file the affidavit of admission and denial of document on the date fix along with the suggested issues.
Grateful, Milord.
My application. Lord, we had to take out this application in light of failure on part of the defendants to disclose documents in compliance of your lordship's order. Now, my lord, what has transpired is this, my lord.
Before he starts, Milord, I must tell your lordship, application can be heard. I have no problem. Thing is, he wants discovery of documents. I have been able to gather a list of 18 or 20 documents, but this is not all. If he wants,
they can't come up now with the documents.
very well, then that can be heard. These are the documents. I have prepared an affidavit. If he wants inspection, he can take inspection, or else these documents can go in. But that has nothing to do with this application. But the application is primarily for striking out of my defense on the ground of non-disclosure. So, Milord, if he wants to move his application, how do I stand in the way?
Now, my lord, I was on twofold issues. My lord,
If he is ready with the document, complete that.
my lord, I have no problem. I'll take inspection if he offers, because I don't want to stall the suit. They have been very successful at doing it, because the initial orders of August 24, 10 months gone, nothing has happened. I have already filed my suggested issues. They have not come up with it. So, my lord, lordship will kindly, my lord, dispose of the application with the direction that they let me have this inspection within this week. And, my lord, we want to proceed with
How soon you will give the document for inspection?
Subject to these documents already being part of the written statement.
Correct.
If they are not, my lord, there's no point in us taking inspection.
Milord, I am handing over the list. Copy inspection with the original. Do you want original or you will take
Original.
the original?
What about your document?
I've already disclosed the
Inspection
They have taken
completed.
inspection, everything done.
Milord, all may not be in original because there are
There'll be certified copies of it.
order copies or the
Whatever not, then he mention it, I
Yes.
will record that. So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed the present application being GA Com 5 of 2024, praying for striking of the defense of the defendant number 1 and 2.
Look, I believe Mr. Dutt is appearing only for one.
I'm only for one.
Who is for the 2?
That is this delay, Milord. If your lordship really wants to know, it's because of this.
And Mr. Ray, the government fleet is there. I don't know.
Mr.
I
Ray,
thought I was appearing for one.
State of West Bengal.
But if no one else is there, because I thought I was appearing for one.
No, after
But
seeing
it
you,
appears
then it is the state of West Bengal is fulfilled.
Yeah, the guardian is there.
Yes.
But I was appearing for 1 and 2, but it appears that Mr. Dutt is now appearing for 1 minute. I'll appear
So
for
I
2
have
minutes.
I have a junior in one and a leader in two.
So you decide who is the leader in one.
No, no problem. Obviously, Mr. Dutt is senior to him.
Lord, in that event, well, as far as one is concerned, let us have
And
the
what
inspection.
about your document? You will not disclose any document.
It kindly gives me 7 days
No,
time.
no. So I am giving both the defendant disclose their document to the plaintiff within 10 days from this.
Fine, we'll do that.
Next week off, Milord. Next week is only 2 days.
But it appears that next week you're going to have a continuing
No, by 25th. By 28. By 28.
Very well.
By 28.
Very
and the on receipt of the plaintiff is will complete the inspection by 5th of May.
Yes, my lord.
Let the matter appear on 7th May.
Lordship. Let the application stay then, my lord.
Because in the event they don't, then I'll have to press.
Very well, let him press that.
Please.
Let him press that.
1 and 2, 1 and 2,
And it is setting.
and to taken off and to taking off the written statement from record.
And my lord, we have already filed our suggested issues on the previous.
The counsel, when the matter is taken up for hearing, comma, the counsel for the defendant submit that they will disclose their document to the plaintiff within on or before 28th of April 2025 and full stop. In view of the above, the defendants are directed to disclose their document on the plaintiff on or before 28th of April 2025. On receipt of the documents, comma, the plaintiff is directed to complete the inspection of the documents by 5th of May 2025. Full stop. Let the matter appear on 7th of May 2025.
Grateful.
Withdraw bole chhi?
Grateful.
2025.
I don't think so. Well, only one more thing. Let this reactions be peremptory because August 13 was the first date
It
of
is made clear
2024.
that if the parties, if the defendants fail to comply with the order, the above order, as directed above, to disclose the document to the plaintiff by 28th of April 2025, comma, the application filed by the plaintiff with being GA Com 5 2024 for taken up for hearing on the date fixed.
Grateful minute.
Not today. Next.
This was that specific performance.
Lordship, I am appearing on behalf of
Past
the.
specific.
We are only appearing.
No, brief it up. Now, Lordship, may I? Here you go. Go for it. Year 2. Year 2, man. I. তুমি বলো যে সমৃদ্ধকে যেন 10 মিনিট জানি আমি চুপ আমি চলে আসি সমৃদ্ধ থাকতে বলো এছিয়ে দাও May I start with because this was the case where, according where my case is that the partial specific performance cannot be had because the bar, 3 bars, Lordship remembers, Lordship. Now, Lordship, may I start with one by one? Firstly, on 2 scores, they have to bring about an agreement, has to be entered into by the party. One is extension, one is allocation. One is under clause, one is under
5.3, 3.2, 6.2.
I'm grateful. Well, this 6.2 is
mutual
allocation. 6.4 is the allocation.
Allocation.
Yes. Allocation, yes. And the Lordship, basic judgments, I will show 24 for SCC now. 2024 for SCC 230. Hey, paragraph 21 to 8. Paragraph 21. Lordship, may I also show paragraph 19, page 241 of the judgment. Once the parties committed themselves to a written contract whereby they reduce the terms and paragraph, yes, paragraph 19.
Yes.
Once the parties committed themselves to a written contract whereby they reduce the terms and conditions agreed upon by them to writing, the same would be binding upon them. In the event such a written contract provided for the consequences that are to follow in the event of breach of the conditions by one or the other of the parties thereto, such consequences must necessarily follow. That means if it can't be completed, the way it has to be then completed by mutual consent. And if resisted, they would be legally enforceable. In the case on hand, the agreement stipulated the date of delivery of possession of the apartment for fit-outs with a grace period of 1 year. In terms thereof, the date for delivery of possession of the apartment for fit-outs with the grace period was 30th June. Admittedly, the respondent company did not offer delivery of possession of the apartment for fit-outs by that date. Now, Lordship kindly comes to paragraph 21. Now, paragraph 22, paragraph 22. More recently, in Sri Ambika Medical Stores versus Surat so and so, it was observed that through its interpretative process, the court cannot rewrite or create a new contract between the parties, and has to simply apply the terms and conditions of the agreement as agreed between the parties. But this is the proposition. So these two, mutual consent has to be, so that is how the parties agree. So that is how it has to be done. So that is, on this score, Lordship kindly also see, Akita. I will not multiply judgment. This is a very basic proposition, Lordship. May I come now to the 68th Supreme Court now? Karnataka, no, the 68th na. Amar tumi tao holo. 68. Yes. 68th Supreme Court. That's in the compilation. We are given a compilation of judgment.
Yes.
The first judgment in the compilation.
1968. Polipara.
This is paragraph 3. Let me come. Paragraph 3. Page 4. Yes. Yeah, 1968 Supreme Court 10.
Para 3.
We proceed to consider the next question raised in these appeals, namely whether the oral agreement was ineffective because the parties contemplated the execution of a formal document, or because the mode of payment of the purchase money was not actually agreed upon. It was submitted on behalf of the appellant that there was no contract because sale was conditional upon a regular agreement being executed, and no such agreement was executed. We do not accept this argument as correct. It is well established that a mere reference to a future formal contract will not prevent a binding bargain between the parties. The fact that the parties refer to the preparation of an agreement by which the terms agreed upon are to be put in a formal shape does not prevent the existence of a binding contract. There are, however, cases where the reference to a future contract is made in such terms as to show that the parties did not intend to be bound until a formal contract is signed. The question depends upon the intention of the parties and the special circumstances of each particular case observed by Lord Chancellor Cranworth. The fact that the fact of a subsequent agreement being prepared may be evidence that the previous negotiations did not amount to a concluded agreement. The mere fact that the persons wish to have a formal agreement drawn up does not establish. Here, this is not a case where they have said that the parties had agreed to this allocation in this manner and a mere formal agreement was required to be done. But this was a case where the agreement had to be reached in future.
Yes.
Your Lordship, the next judgment is 1912-1, Chancery Division 284. Starts at page 6, at page 10. Last 3 lines. Last one. It appears to be well said by the authorities that if the documents or letters relied on as constituting a contract contemplate the execution of a further contract between the parties, it is a question of construction whether the execution of the further contract is a condition or term of the bargain, or whether it is a mere expression of the desire of the parties as to the manner in which the transaction already agreed to will in fact go through. In the formal case, in the former case, there is no enforceable contract, either because the condition is unfulfilled or because the law does not recognize the contract to enter into a contract. In the latter case, there is a binding contract, and the reference to a more formal document may be ignored. You will see nowhere in the plaint that they have made any averment as to the mode of allocation, either 6.4 or 5 points. There is no averment that there was an agreement reached or the parties agreed to, and it's a matter of the court then interpreting, especially 6.4 at page 149, without which the agreement cannot be worked out at all. One does not know what will be the allocation.
Yes.
That is the crucial part, because otherwise building will come, but then who is the owner will be a future dispute.
Yes.
Then 9-1 in 2009, 1 SCC, page 475. Starts at page 13. Kindly come to paragraph 22, page 19, running page 19.
Yes.
Paragraph 22. The said letter of intent on a bare reading is nothing but an agreement to enter into another agreement, because it is provided in the said letter that both parties agree to have set a deadline to sign this agreement by 15 September. It is a well-settled legal position that an agreement to enter into an agreement is not enforceable, nor does it confer any right upon the parties. The agreement in terms of the letter of intent was to be signed on August 1. It is not the case that an agreement was executed. Parties, this one has not stated in his counter reply that the agreement which was to be executed by 15 September was in fact executed. During the course of hearing, it's fairly conceded that no such agreement was executed. Parties, hence. And the last judgment on this starts at page 21. at page 23, that is 1970, volume 1 weekly law reports, 426 at 428.
Yes.
Kindly come to Placetum D. Placetum D. The argument for uncertainty is that as the rent was not agreed and was left to be agreed, unless the parties were, if you like to put it that way, to play the game together and agree, the contract is not enforceable and is void for uncertainty. In substance, it amounts to no more than a contract, to enter into a contract which is always given as the classic example of an agreement which is unenforceable. The cases on that sort of point are well known and I need not refer to them. However, I have, through the industry of counsel, had my attention drawn to Young versus Van Benin, a case in the Court of Appeal in British Columbia, and Mr. Mallard relies as part of his argument upon the decision of the court in that case. It is a case very similar to the present one. I just refer to the head note, which is in the following terms. Where a lease provides that the tenant has an option to rent the premises for a further period, fixing no term except the length of such period, and having the rental to be determined by agreement between the parties. Such provision is too vague and indefinite to be capable of enforcement, and does not confer upon the tenant any right to a tenancy which is enforceable. In the absence of a supplementary agreement fixing the terms of the new lease, the tenant is bound to surrender permission. Apropos, this lordship also sees a prayer. They're only asking for power of attorney to be given. That will not take care of 5.3. That will not take care of 6.4. So they are not even asking the court to settle those terms, if it's at all possible for the court to settle the terms. They are simply to execute the power of attorney. I can ignore it then. Then the court's decree can be, one is to by setting it aside, or the other is to say you take a power of attorney, but then you can't construct because the time has expired. You can enjoy the power of attorney. You can't allocate amongst each other. So whatever it is there, it's remain as it is.
Yeah.
The next part of my argument is on the power of attorney. In fact, your lordships also recently delivered a judgment on power of attorney is always revocable unless it is irrevocable. And in fact, lordship had relied upon the judgment in the case of in Calm Industries. My lord has recently please the Church of Christ Charitable Trust. It is 2012 8 SCC, page 706. This, in fact, my lord has quoted also in this Calm Industries. Suraj Lam dekha diye tumi. Suraj Lam. Lordship, kindly take a look at the Suraj Lam. Soft copy chhe dao. To ওটা কি আছে ক্রাইস্ট চার্চটা আছে না ওটা নেই ওটা আছে না সফট কপি ছাড়ো Lordship kindly takes a look at Suraj Lamps, that is page 25 of the compilation, 2012 1 SCC, 2012 1 SCC 656.
Yes.
Paragraph 20. Page 35 of the compilation.
Yes.
35 of the compilation.
Paragraph 12 of the judgment. Very well.
We don't have the compilation. If you
Not
say
given the
page
copy.
35,
We should be
page
giving it.
35
I will give
of
it-
compilation.
have this and the
Hey,
hard
point-
copy.
do it
I mean,
point date,
we-
point
we-
date.
this
We
soft
will
copy
give
Mr.
it.
Basawa.
No, we could have read it along with you. Otherwise,
Yes, I know. It is an advantage. It's not finished today. So, paragraph 20. 666. Power of attorney is not an instrument of transfer in regard to any right, title, or interest in removal. The power of attorney is creation of an agency whereby the grantor authorizes the grantee to do the acts specified therein on behalf of grantor, which when executed will be binding on the grantor as if done by him. It is revocable or terminable at any time unless it is made irrevocable in a manner known to law. And in our case, as your lordship had seen, it is expressly made revocable by saying that this will create no right whatsoever. Page 177, lordship had noted that. At page 186. Be it noted that the power of attorney is page 186 of volume 2. It starts from page 177 at page 186, clause 12. Page 186, clause 18 of the paragraph 18.
Yes.
Paragraph 18. Be it noted that this power of attorney is being granted in favor of the said attorney without any consideration, and no interest or right of the attorney is created in the property which is the subject matter of the power of attorney, and that further the said attorney shall not hereby obtain or have any power to any construction, development work on the said property.
Yes.
This was the pre-existing power of attorney. And also lordship sees clause 15, previous page.
Restricted to obtain is
Clause 15. What sanction is already the power of attorney is restricted to obtain sanction and the clearance from KMC and other authorities, not for any development of the premises. This is their prayer. They want this. So they expressly limit the specific performance only this power of attorney.
Yes.
Now, just one more judgment, lordship, on this point in the compilation, that is the other compilation. I want to go to Right, yes. There is a page. There's 2019 SCC Online Bombay. 235. Page 38 of the compilation. Paragraph 13 of this judgment. Running page 40. And this also is revocable.
Storage lamp.
Storage lamp is followed. And now, so it will be, this is really a futile writ. This is a doctrine of futile writs will apply. The court will not pass a decree which is futile. Firstly, this power of attorney will be of no use for development. Secondly, this can be revoked next day. For that, I rely upon AIR 1964 Supreme Court, page 11. Paragraph 39. That is 47 of the compilation. It starts paragraph 39 of this judgment. That is at page
59.
59. I venture to think that the contention dealt with by the court in Baibhuri's case, first appeal, was based on misapprehension. So, last paragraph. Neither does it seem to me that the order can, last line, be treated as one curing an irregularity, as a case where the counterclaim had been a plaint from the beginning, but as it had not complied with the rules concerning a plaint, it had been a plaint irregularly filed. First, the respondent never contended that they had filed a plaint. They said they had filed a written statement in which they had made a counterclaim, and that counterclaim was maintainable as such. That was their contention. They persisted in this attitude all through. They did not even raise an issue as to whether they were entitled to treat the counterclaim as a plaint. It would be strange if the court said that the respondent have filed a plaint, though they did not themselves say so. Secondly, I am aware that a plaint, I am not aware, how is it, Dr. Futile Doctrine of futile, how is it relevant here?
I am not aware there's a plaint.
This is impossible, but proceeding must. No, this is not. This judgment is not at least this paragraph. No. This must be some mistake. Must be some mistake. Who judgment? But you kindly sit. Takes the next judgment. The judgment. EIR 1981, Supreme Court 136. This is either the paragraph number is wrong or page 136, paragraph 17 and running page 70.
Running page?
70.
Yes.
Paragraph 17. Linked with this question is the question whether the failure to observe natural justice does not at all matter if the observance of natural justice would have made no difference. The admitted or indisputable facts speaking for themselves. Whereon the admitted or indisputable facts, only one conclusion is possible. And under the law, only one penalty is permissible. The court may not issue its writ to compel the observance of natural justice, not because it approves the observance of natural justice, but because courts do not issue futile writs. It will be pernicious principle to apply in other situations where conclusions are controversial, however slightly the penalties are discretionary. From a different angle, Doctrine of Futile Writs, page 72 also, just above paragraph 25. Now, a more apt judgment will be the next judgment of Tamil Nadu High Court, where factually apt will be the page 74. This is reported in Manu TN 0034/1999. I'll give you copies. Paragraph 20 at running page 77.
Yes.
Secondly, it is also to be remembered that the relief of declaration is to be granted only at the discretion of the court, on being satisfied with the necessity to grant such a relief, having regard to the fact that in the present case, the relief of declaration would only be futile. Known discretion can be exercised in favor of grant of such a decree. It will be a decree which will not have the effect of granting any right in favor of any of the parties or divesting the rights of opposite party in any manner. The board will be still entitled to enforce payment of the dues as a result of threat of disconnection. And no court can grant a futile decree or order. The courts cannot grant a declaration when it is of no utility and can be ignored by the party against whom the declaration is issued. The principle of brutum fulmen is applicable in the present case, which is defined in Black's dictionary as follows: an empty noise, an empty threat, a judgment void upon its face, which is in legal ethic no judgment at all, and by which no rights are divested, and very much none can be obtained, and neither binds nor bars anybody. Here, this power of attorney, they can't develop, they can't construct, and I can terminate. So with this power of attorney alone, this limited specific power means I don't know why they limited that to only specific power, limited to this extent. This they get nothing. Next, I move on to they're quantifying the loss suffered. That will deprive them of their right to claim specific, especially when I am willing to deposit the money or pay the money. So, to bring it to an end, their averment in the plaint that this is the amount of monetary loss they have suffered. May I continue next day because it is 3 o'clock? I also have a fixed matter. Okay. So any day, if it can remain in the list, we can.
Let it be remain in the list.
Let it remain.
Suffering for the plaintiff, suffering for the defendant. Counsel for the defendant has argued the matter at length in connection with GA2 of 2022, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow under the same heading.
Great.
In my note. 28, 20, 32.
32. This is my application for recalling of an ex parte decree. The pleadings are complete, my lord. I can start, my lord.
3 minutes, you will complete 2 minutes now.
Only one thing, my lord, regarding the 3 p.m. fixed matter. Mr. Thakkar is on legs addressing a division bench. So, my lord, if it could continue, may I pray for a short pass?
I can.
For the other side.
Mr. Bhattacharya is for one of the other sides, but
which one? Which
that,
matter?
that
Toward him, that
Italian. আজই করে মানে
অন্য কোনো দিন করে তাহলে then keeps it on some other day মানে day after
কবে আছে না আছে বাবা আমি জানি না একটু দাঁড়াও প্লিজ
আমাদের তো বলতে হবে
বলবে তো একটু দাঁড়াও
ওদের মহিলাকে তো ওদের রিপ্লাই দেবে
আচ্ছা he has to give the reply to the 6 and 7.
Yes, but I am for 10 I will take 10 minutes my lord, not more than 10 minutes. Kindly keeps it day after my
then
lord.
Let him
he can
No, what I on the last occasion, what I proposed, because the defendant number 6 and 7 had been to the appellate court. Appellate court directed his application is to be disposed of. So he has filed the affidavit. So I
but we have also filed our affidavit. That's not an issue, my lord. It can't be heard piecemeal.
All I
are on the same sailing on the same boat.
All I am seeking, your lordship will kindly take it up a little later. That is all I am seeking.
So that
he's
I conclude, Mr.
You are having any matter at the court?
Huh?
You are having any matter?
Okay,
no problem. I am taking this matter first. If the Mr. Thakkar will come, time permit, I will hear Mr. Thakkar, no problem. Then you can argue the matter. With regard to the reply of 6 and 7, then whatever your submission. Yes.
Mr. Bhattacharya, I believe, will be making his submissions today, my lord.
Yes.
My lord, may I give my reply on the next day, my lord?
This is in respect to item 32, my lord, Mr.
32,
oh, I thought it was called. I'm so sorry.
Your lordship, because it's a recalling of my lord, this is what an order, my lord. Item 33.
Item 33. Give the
So the prayer is the way it is couched, my lord. Also, we are seeking recalling. Looks at the prayer.
Recall the 3rd July. Okay.
Yes, my lord.
Item 33. Item 33.
First prayer is
suffering for the plaintiff. You are for the defendant?
Yes.
Plaintiff.
Defendant.
Suffering for the defendant. Defendant has filed the present application being GA Com 5 of 2025. Praying for recalling of the order dated 3rd July 2024, passed by His Lordship. Passed, 24, passed by Justice Bivas Patnaik. Full stop. In view of the above, let the full stop. Considering the above, comma, GA Com 5 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court for listing the above matter, listing the instant application. Yes.
Yes. Your Lordship, may I indicate that Mr. Ray is leading me in the matter?
My lord, I was only
I'll,
submitting, my lord, if I can give my reply on Thursday, my lord, if it's possible, my lord.
I'll take
Okay, let it come.
Yeah, I know, that's why he will take time, I understand, my lord. So that's why I'll give my reply on Thursday, my lord. I'm not there tomorrow, my lord, if your lordship kindly considers. Very grateful to your lordship.
application for recalling of an ex parte.
Where is the order?
29th of April 2024, page 74.
Page 74. By this court?
Yes, yes. Your Lordship's order. Your Lordship, decree. 74, my lord, is a money decree. My lord will find the operative portion at paragraph 32, which is at page 84, internal page 11. And
80 lakhs along with interest.
80 lakhs interest is also directed to pay 1 crore 59 lakhs along with 18% interest. But the suit was filed on the premise that there was a lease deed which was executed by the defendant in favor of the plaintiff. And despite of execution of lease deed, receipt of security deposit and monthly rent, possession of the leasehold property was not given by the defendant to the plaintiff. That was the premise of the suit being filed. Now, in my case here is that no writ of summons was at all served upon the defendant at any point of time. My lord will kindly seize the plaint first. Plaint, my lord, is at page 15.
50?
Or 15.
Yes.
Page 15, my lord will see the description of the defendant. Balaji Hydrocarbons Private Limited, a company incorporated under the Companies Act, having its office at 19 Kenderdine Lane, 3rd floor, Kolkata 700012 within the aforesaid jurisdiction. So office shown to be at a location which is within jurisdiction, so therefore no requirement of clause 12 leave being taken. Now this suit has been filed on, in fact, my lord will find from page 18. This is on July 2017. It's filed in July 2017. Now, this office, Calcutta office of the defendant, which they have, which they say, or this office in court, this was surrendered. Possession was surrendered by the defendant in October 2016. Document to that effect. Not only that, this more interesting part is that the defendant is a company having a registered office. The registered office of the defendant, my lord, will come from the master data, which is at page 95. It's part of the master.
What is the there is an agreement?
Lease deed.
Where is that?
Yes.
What is the address mentioned in that?
Page 37. Yes. This Balaji Hydro Kenderdine, yes, 2015, because the lease deed of June 2015. On that day, there was a Calcutta office. October 2016, that office was surrendered. But be that as it may, that it is a company which has a registered office. The registered office at page 95. Well, we'll see the registered office. This is part of the master data. Nasir Avenue, Durgapur.
Yes.
So the register, and it is
it cannot be the case of the plaintiff that they were not aware of the registered office.
Yes.
That's the reason, my lord, I had shown that the suit was filed in fact, the date of filing, I'm told, is exact date is 17th of July 2017.
Yes.
Prior to the suit being filed, 5th of July 2017, my lord, comes to page 58. Page 50. We will see the date, my lord. It's Aquila is the plaintiff's advocate, 5th of July.
58.
Page 58 of the application. In fact, this is part of the plaint. This is something which is not being disclosed. It's part of the plaint. 5th of July 2017.
Yes.
Aquila. Our client is Himadri Specialty Chemicals as a plaintiff. Kindly sees the address to whom they're addressing. To which address? To Balaji Hydrocarbons Private Limited, Nasser Avenue, Industrial Estate, ADDA, Muchipara, Durgapur 71312.
Yes.
So prior to filing of the suit,
Yes.
the plaintiff is aware of the registered office of the company.
Yes.
The plaintiff did not, the plaintiff could have possibly given the address of the registered office and filed the suit and taken leave under clause 12. Simpliciter money claim, taken leave, shown part of cause of action to have arisen, and filed the suit. It chooses not to do so. Now, I will come to the legal implication of Code of CPC also requires when a suit is being instituted against an incorporated company, and also the company court rules that what is the service of notice on the company. I'll come to that, but some factual aspects first, Mala, before that. Now, this was in respect of a license, which was this office premises were used as a license. Now, page 91, that license was terminated with effect from 31st of December 2016. That's page 91.
Which license?
The license which, my lord, was
Agreement.
in favor, like for using the Calcutta.
That agreement.
Yes.
Agreement.
The leave and license agreement.
Correct.
Between the defendant and defendant's landlord. That was, my lord, terminated with effect from 31st December 2016. Page 91.
91.
Yes, page 91.
Yes.
Agreement ending on the days of further, we would not be renewing the agreement. In fact, it's our letter. We have said that we will not be renewing the agreement beyond 31st December 2016.
Yes.
So now, what possibly they can argue is that even after that, our subsequent letterhead was not changed. The defendant, my lord, will see the letterhead of the defendant, which is at page 91. The letterhead continued to reflect the city office as Kolkata. So that is possibly, they might say that we were also, but the fact still remains they were also aware of the registered office. Now, when this suit was filed, initially they could, the summons. Now, interestingly, why we were not in possession, because summons could not be served on the city office because we were not there. Then the plaintiff took out an application for substituted service. Now, as I have shown to your lordship, my lord, plaintiff was aware of the registered office. Lord, kindly sees their application for substituted service, which is in their affidavit in opposition, page 30.
Yes.
Page 13, it starts. Kindly comes from paragraph C, from para 2 onwards, page 15.
Yes.
Subsequent to filing of the civil suit, this honorable court was pleased to direct issuance of summons. However, it has come to the knowledge of the plaintiff that the summons have been returned unserved with the following comments. Personal service through second officer could not be served upon the said defendant because the door of the defendant's office was closed and the defendant was shifted their office to another place about 6 months ago. B, postal service, registered post, undelivered, packet marked, left for the defendant.
Yes.
Now, service report and officer was annexed. I'll not trouble your lordship with that. Now, kindly comes to paragraph 3.
Paragraph
3, the next paragraph of the application. Your plaintiff submits that upon inquiry, it has come to the knowledge of the plaintiff that the defendant has a new address. The defendant has a new address at Nasir Avenue, Durgapur, Kolkata, and the same is reflected in the master data is available in the website of Ministry of Corporate Affairs. Prior to filing of the suit, their own notice goes to my registered office.
Okay.
And in the application for substituted service, they make out a case of as if a new address they have come to learn.
Okay.
Now, kindly seize, my lord, the press in the application. Pass an order of service of summons of the aforesaid suit upon the defendant through speed post and a registered post as Nasir Avenue, Durgapur, Kolkata. And in the alternative, prayer B. Pass an order of service of summons of the aforesaid suit upon the defendant through substituted means by publication of advertisement in a daily English and Bengali newspapers, which has gotten wide circulation in the locality in which the defendant is last known to have carried on its business.
Yes.
So now the order which is passed, which they obtain, is 28th of June 2023. My lord, oh sorry, it's not, it's 17th August 2022, which is at page 22.
Yes. Yes.
The plaintiff has, I'll just place this order, my lord. That's one page.
Yes, publication was allowed.
Considering the prayer council preparing a different document, prayer is allowed. Plaintiff is directed to take appropriate steps for substituted service of the notice of the instance suit by publication of the same, one in English newspaper and one in Bengali newspaper within 2 weeks from date. So this is in effect in respect of prayer B, where they have said in term as per the last known address. And now the publications, my lord will see page in the affidavit in opposition, page 23. Is kindly see where it has been published. Times City, and on the right hand top, Kolkata.
Times of India.
Times of India, but Times City. Kindly see left hand top. Times City edition, and then on the right hand top corner, but just below annexure C, the Times of India, Kolkata. So Times of India, Kolkata's Times City edition. The city edition. Because Times of India has a city edition, which is Times City, which is published in respect of circulations in Kolkata. And now, এই সময়, the next, it's in Bengali, my lord will, শহরতলি দেশ, and on right top corner, এই সময় Kolkata.
Yes.
So, but whereas this last registered office is in Durgapur, it has not been shown possibly as to how Times of India, Times City edition newspaper published is also circulated in Durgapur. Or an Eshamai.
Have you taken the plea in the affidavit reply?
Yes.
Times City is not published in the.
Yes, I have. In fact, since my lord has it has fallen from your lordship, my lord, may I just indicated this relevant.
So you do one thing. Let it be stop here. Mr. Bose has also come. Mr. Thakkar has also come. Let that start. Now,
may it appear on Thursday as Mr. Ray was. I'll continue with my submissions.
So appearing for the plaintiff, so appearing for the defendant, counsel for the defendant, and the defendant has filed an application being GA Com 2 of 2024 for setting aside of the judgment and decree passed by this court dated 29th April 2024. Counsel for the defendant has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 10th April under the same heading.
Grateful, my lord.
Grateful. Deeply.
Policy fixed matter item number 34. My other side is here. This is with regard to clause 49 and 50 of that agreement. Milad, I have some difficulty. Milad, kindly check it any day after the long
Tomorrow?
vacation.
Not today.
On Milad, we are Milad agreed Milad after the vacation Milad.
After the vacation.
long.
So appearing for the plaintiff, so appearing for the defendant. 34, huh?
34.
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the parties, the case is adjourned. Let the matter appear on
21st, that week of 21st, after that.
21st of
Milad,
April.
That week, Milad, 18th is a holiday again, Milad.
On 22nd.
Milad, the interim order is expiring.
When?
Milad,
The interim order is extended till 25th of April 2025 or until further order.
Obliged.
Whichever is available. Yes.
Number 6. Sorry, my lords, I was engaged in another matter. I'm very sorry, man. And I'm to reply to the submissions on behalf of the defendant number 6.
That is complete, and thereafter Mr. Thakkar can reply.
Thakkar already argued the matter, I think.
I'm for defendant number 10.
How much time you will take?
Half an hour. He one small point. After that.
Half an hour.
So Mr. Thakkar was responding to respondent number 6 submission.
Let Mr. Thakkar complete this because I have taken
The 6. The 6 and 7. Defendant
No,
number
I will,
6
I will, I will hear you, no problem. Yes.
Petition. My lord, I was kindly permit me a slightly unconventional way of doing it. I don't think, and now we have learned from them. We've got that AI transcript of the entire argument, quote unquote, whatever Mr. Bose has argued now. My juniors have also learned from him, so we have also got that. Now, I don't think, my lord, there is any factual position remains uncontroverted. So I'll not trouble your lordship too long with the facts. May I start with the law first? Kindly have the judgments which are shown to your lordship, my lord. Kindly have Union of India, Raman Iron Foundry. Facts, I don't think I have to deal with much. So I'll deal with the law and I'll continue. Kindly have, my lord, Union of India, Raman Iron Foundry. Now, my lord, Union of India, Raman Iron Foundry, 1974 to SCC 231 was relied upon for the proposition that a claim for damages cannot be secured.
Yes.
So this is the, my lord, proposition, paragraph 8 onwards, this was relied upon that a claim for damages cannot be secured. I cannot join issue with this judgment or the applicability. But the issue is of the applicability of this judgment in the facts of our case, whether I have a claim for damages simpliciter against the defendant number 6, or I have a claim for return of money also. My learned friend has argued that my claim against defendant number 6 is only for damages, nothing else. That is not factually correct. Kindly see the paragraphs of the petition once, please, my lord. Kindly have paragraph where I have said about claims for what are the claims against each of the defendants. Kindly give me a minute. Paragraph page 65, your lordship kindly comes.
Of the application?
Yes. Of the application.
Yes.
Third contract onwards, hai to. These are in respect of, matlab the third contract. Ek aur page hai, nikalo, it's not page. Kindly come to paragraph 108. At page 67.
Yes.
The plaintiff has made, your lordship has that? Plaintiff has made aggregate payment of 585,000 euro, being the price of 1,000 metric tons under the third contract. However, it has received delivery of only 757 metric tons, valued at 442,000 or 442,845 euro. Therefore, the plaintiff is entitled to receive the excess amount of 142,155 euro paid by it. So this is a simpliciter claim in money. The claim in damages is paragraph 110, which was shown to your lordship. Can you see 110 now? 110 is the claim for damages. There are two limbs of claim against D6. Can you see 110 at page 68? By reason of the failure of the defendant numbers 1 to 5 and the defendant number so-and-so to supply the goods under the third contract, plaintiff was compelled to cancel all the contracts. Plaintiff in usual course of business would have earned a profit, being the difference of price between the cancelled contracts and the contracts with the defendant number so-and-so aggregating to so-and-so. So 110 and 111 is the claim for damages for loss of profit, and 112 is the excess price which I had to pay. Therefore, if your lordship now comes to paragraph 117 at page 72.
Yes.
Serial A, excess payment as stated in paragraph number 108 herein above 142,000 euro is simpliciter refund of price excess. B, C are in the nature of damages. D is again in the nature of interest on the outstanding amount. So it is wrong to say that the claim is only and only for damages. Claim is both for an ascertained liquidated amount of money, which is the excess price paid, and then is damages. And this is identical for all the contracts. Now your lordship will kindly see the next paragraph apropos this. Paragraph 128 at page 80 top.
Yes. Excess payment.
Excess payment. The other two are damages. And detention charges is also the amount of money which I have paid already. So only B is in the nature of damages. A and C are in the nature of recovery of money. Excess money paid for goods not delivered. Similarly, kindly see page 92, paragraph 142, first entry. Excess payment only. Because I have not suffered any damages in this. I have not got into any contracts. I have not suffered any loss of profit. I have not bought any other goods. So I am simpliciter claiming that you give back my excess money which you have received.
Yes.
So, my lord, to say that the claim is only for damages and therefore cannot be secured is factually incorrect.
Okay.
That takes care of Raman Iron Foundry. Now, your lordship kindly sees Raman Tech Process 2008-2 SCC 302 and 2022 SCC Online SC 1329.
What is the citation?
My lord, 2008-2 SCC 302 is Raman Tech and Process Engineering Company, and 2022 SCC Online SC 1329. Subject to correction, my learned friend cited 4 decisions. One is Raman Tech, one is Sanghi, and one is and Harleen is the last, correct.
Raman Tech and
my lord, Raman Tech and
2006.
Sanghi Industries. 2022 SEC Online Supreme Court 1329.
Sanghi, yes.
Kindly have Raman Tech once, please, my lord.
Yes.
Kindly see paragraph 4, placetum B, the object of order 38 rule 5 in particular.
That they have relied on.
They have relied on this, and also 6. So, my lord, both these decisions are in the context of order 38 rule 5. Order 38 rule 5 contemplates of attachment before judgment. Now, if your lordship kindly sees the relief which I have sought here, I have not sought any relief in the nature of order 38 rule 5. I have only sought a relief of order of injunction restraining them from operating their bank accounts without keeping aside this much money. Order 38 rule 5 test need not be satisfied because this application is not in the nature of order 38 rule 5. No reliefs as contemplated under order 38 rule 5 are sought. And the distinction, what this application is borne out from my learned friend's judgment, 2021 Calcutta Law Times 631, Harleen Jairat versus Prabhasurana, where the division bench of our court has very lucidly explained the distinction between order 38 rule 5 and order 39 1B, which is injunction, which is what this application, my application, is about.
Yes.
Kindly have, my lord, 2020, your lordship has Harleen Jairat versus Prabhasurana.
Para 38.
Before that, my lord, may I just trouble your lordship with paragraph 24 once, just for the sake of completeness, to show that our court was conscious of order 38 rule 5 and Raman Tech. Kindly see paragraph 24.
Yes.
Paragraph 24, just to satisfy your lordship's judicial conscience that Raman Tech was noticed. He relies on Raman Tech is noticed here. Then, my lord, kindly come to paragraph 36. However, paragraph 36 at the bottom of page 9.
Yes.
However, there is a distinction between attachment and injunction. According to dictionary meaning, attachment means act of attaching, state of being attached. In law, it is seizure of property by a seizure of property or person by legal authority, especially seizure of defendant's property to prevent its dissipation before trial. Now, the distinction is, notice the word attachment has been defined as so-and-so. Then kindly see paragraph 14 of the Boeing company decision, which is extracted. In fact, injunction is different from attachment. I'm sorry, my lord, in paragraph 37, your lordship would see after the bold, the said distinction was discussed. Your lordship has that?
Yes.
The said distinction was discussed by the division bench of this court in the case of Boeing Company versus RM Investment and Trading so-and-so, paragraphs 13, 14. Then kindly see 14. In fact, injunction is different from attachment. The Code of Civil Procedure has provided two different provisions for the same. An attachment is a proceeding to collect and enforce a lien. It is a remedy for the collection of an ordinary debt, whereas injunction restrains the disposition of property. It is not an attachment of property. Injunction does not constitute a lien on the property. It could be granted only when equity, justice, and good conscience of the party needs it. Then kindly see 39. So 38 also, please, my lord. There is a distinction between the provisions of Order 38 Rule 5 and Order 39 Rule 1B, in that the former is intended to prevent a decree that may be passed from being rendered infructuous, while the latter is invoked where the defendant threatens to dispose with a due to defraud creditors. In the decision of a division bench of this court in Santosh Promoters, the relative scope of both the sections have been lucidly discussed. In it is thus stated. So, my lord, Santosh Promoters, I'm not troubling your lordship with. Kindly see now paragraph 40, where it was contended in that case that Santosh Promoters is per incurium. That was rejected. Then kindly see 41. In issuing temporary injunctions, the tests to be applied are whether the plaintiff has a prima facie case whether the balance of convenience is in favor of the plaintiff and whether the plaintiff would suffer an irreparable injury if his prayer for temporary injunction is disallowed. The interlocutory remedy is intended to preserve in status quo the rights of parties which may appear on a prima facie case. So this is the test, my lord, which we are concerned with here, whether I've been able to satisfy this test, not the test of Order 38 Rule 5. At the stage of deciding the application for temporary injunction, the court is not required to go into the merits of the case in detail. What the court has to examine is the plaintiff has a prima facie case to go for trial. Protection is necessary from that species of injuries known as irreparable before his legal right can be established, and that the mischief or inconvenience likely to arise from withholding injunction will be greater than what is likely to arise from granting it. Then kindly see 43. This was also a simpliciter case for money lent in advance. Kindly see 43. At this stage, we find that there is no explanation offered for the two confirmation of accounts followed by the letter dated so-and-so in which the defendant number 1 and her husband has clearly acknowledged that the plaintiff and her husband from time to time lent an advance money to Shanti Surana and Prabha Surana for their business purposes on a long-term basis with interest at the rate of so-and-so. Several monies have been lent in advance. The said letter clearly establishes jural relationship and confirmation. Those are the facts of that case. Simpliciter case for money lent in advance. Then 44 onwards. Then kindly see 45.
Yes.
The law is required to be interpreted and applied in a manner so that no injustice is caused to the rightful claimant. The law cannot be a lame duck. The situation in the 1950s and the situation in 2019 are completely different. The commercial world has changed. Recent developments all over the world have shown that commercial morality has remained merely as a concept. It is more honored in breach than in observance. The modus operandi to make a decree ocious and illusory by an unscrupulous litigant apprehending that the decree is imminent by adopting devious and clandestine means are well known, and law courts are very now and then facing such situations. Should a court faced with an unimpeachable claim wait for an unscrupulous litigant to deliver its defense and the luxury of a trial, by which time the chance of recovery would be lost forever? In Abhaya Realtors, two aspects need to be seriously concerned. At the time that the Civil Procedure Code came to be made, suits would not take years or decades to be brought to trial, as it is usually the case these days. The strength of the principle that an apparently good claim would not justify an order of attachment to be made for final judgment is rendered needs to be seen with reference to the time and place in which such principle was born. The second aspect is that even without a defendant attempting to defraud its creditors or the plaintiff, the vicissitudes of the commercial market may leave the defendant with little to offer as judgment debtor upon the decree being made. The sheer passage of time between the institution of an action and the trial thereof that has now come to be accepted as par for the course may make the claim irrelevant or even the claimant disinterested. That would result in an erosion of the confidence in the system and lead suitors to undesirable quarters for more effective results. But this may not be the ideal action for such considerations to have a hearing. Then 47, in so-and-so Supreme Court, the courts have inherent jurisdiction to issue temporary injunctions in circumstances which are not covered by the provisions of Order 39 CPC. It is well settled that the provisions of the code are not exhaustive for the simple reason that the legislature is incapable of contemplating all the possible circumstances which may arise in future litigation and consequently for providing the procedure for them. The court exercises its own inherent jurisdiction only when it considers it necessary. Even prior thereto, in two Calcutta decisions are noticed, the High Court held that the law cannot make express provisions against all inconvenience and therefore had inherent power to act ex debito justice where the circumstances of the case required. Court held the balance of convenience enabled the court to pass the temporary order of injunction. Relevant extracts I'm not troubling your lordship with. Paragraph 48, in Chinese Tannery Association, the Calcutta High Court was examining an interim order of injunction that had been granted in favor of the plaintiff in a suit for money decree. The defendant appellant raised the plea that the provisions of Order 39 Rule 1 was not applicable and the civil court could not have invoked its inherent power under Section 151. The division bench held that the mere fact that there are certain provisions as regards the issue of injunction in 39 of the code does not debar the court from passing temporary injunctions for doing justice in the exercise of powers under 151. Relevant paragraphs are as follows. I'm not troubling your lordship with the entire decision because the summary is given. Then kindly see paragraph 49. There cannot be an absolute proposition that in a money claim, no order of injunction or attachment or receiver could be made. Order 38 to 40 of the civil, 38 is receiver, 39 injunction, 38 attachment before judgment, then injunctions, and then receivers, does not restrict the power of the court to pass any order that a court is empowered to pass just because it is a money claim. We have already discussed the circumstances when the court does. If there were doubts about exercising power under any of the aforesaid provisions, it can be safely stated that the court has inherent power to pass an order of injunction or attachment upon an unimpeachable liquidated claim being made, demonstrated, and upon it being established that the respondents are taking steps to deny realization. When a huge sum of money is claimed and the plaintiff prima facie establishes such amount, he would be entitled to secure his interest in keeping in view the amount involved in the suit. And then 39(1)(b), power is exercised. We have no doubt in our mind that in the instant case, court can exercise power under Order 39, Rule 1B, order of injunction can be passed. Plaintiff has been able to establish at the ad interim stage all the conditions required, etc. So this was at the ad interim stage. To the same effect, my lord, is another division bench judgment. Correct. Well, there is another division bench judgment of our court on this, which I have troubled your lordship at the ad interim stage. That is the Tata Chemicals versus Kshitish Bardhan Chunnilal. Perhaps the copy is there, my lord.
Tata Chemicals?
Yes, my lord. Tata Chemicals Limited versus Kshitish Bardhan Chunnilal Nath. Copy was given earlier, my lord. Reported वाला नहीं लाया है. ये दिया है? वो तो इनिशियली दिया था तो.
Must have showed this at the added.
Added text. Right. We relied on all that. Yes. No, Mr. Bose is not objecting in case it's not there.
At best, what your lordship will give me 10 more seconds if I have to say anything. Nothing more than.
The director copy though. In this case also, my lord, there was a case of fraud and division bench of division bench of our court held that injunction could be made to copy tai diye diche. Injunction could be granted, my lord. I'll give your lordship the paragraphs. I had just one copy. I'll give your lordship the paragraphs. They're saying it was handed over earlier, so they've just carried one copy.
Tata Motors are there.
Tata Motors, yes, my lord.
Tata Chemical is not there.
Tata Chemical. Comment center division there. So this judgment is also an authority. The second judgment which I just showed your lordship, I'll give your lordship the Tata Chemicals is an authority for the proposition that Order 39(1)(b), read with Section 151, court has powers to grant injunctions restraining operation of bank accounts when there's a money claim. Order 38, Rule 5 is not the only recourse. And this Section 151, which our court has said long ago, has now been reiterated, my lord, by the Supreme Court also in Rahul S. Shah. But this judgment, my lord, may I just tell your lordship the relevant paragraph? Copy क्यों नहीं लाता है राजेश? Yeah. Kindly have paragraph 100 onwards, please. It is citation হচ্ছে citation টা দিয়ে দাও
2022 SCC online
2022 SCC online cal 3343
Page 100.
paragraph 100 please madam.
Take it on my iPad.
The paragraph number है उसमें.
There's no paragraph. It starts from.
My lord, may I hand over?
airdrop to করে
Yeah. तो unreported copy क्यों लाया राजेश? Next. We'll have the copy, my lord, filed with your lordship's officer before as soon as the hearing ends, my lord.
with marking page.
Hmm. Now, my lord, the claim was for recovery of monies of which Tata was defrauded by reason of fraud. Kindly see paragraphs 12 and 13. Your Lordship will kindly scroll up to paragraphs 12 and 13, please. Similar case of fraud,
Yes.
as in a claim founded on fraud. Now, my lord, Tata Chemicals used to, Kshitij Bardhan Chunnilal Nath, my lord, were dealers of Tata Chemicals. Others are, my lord, employees of Tata Chemicals. Now, Tata Chemicals used to supply chemicals to this Kshitij Bardhan Chunnilal Nath, which your Lordship will get in paragraphs 12 and 13. Now, in order to promote sales, my lord, it used to give rebates or discounts which are marked as credit. Now, what Kshitij, this dealer did in collusion with the employees of Tata, it got excess credits done. So Tata, upon coming to learn of these excess credits, and in those credits were adjusted against price of goods sold and delivered. So they withdrew excess monies and did not pay for the full price of goods. In those circumstances, Tata, my lord, filed a suit claiming recovery of these fraudulent credits which were obtained. In that context, my lord, orders came to be made under Order 39(1)(b). Kindly see 100 onwards, please, now, my lord. The entire fact situation is analyzed and all the judgments are noticed, my lord, as to what is the test. Kindly come to paragraph 100. At the interlocutory stage, the court is not required to hold a mini trial. And I'm sorry, my lord, it is just Mr. Gupta has marked these judgments, my lord. Then kindly see 101, injunction is not a cause of action, etc. The English judgment is noticed. 102, Hurleen Jairat is noticed, my lord, which your lordship has just seen. Then kindly come to 103, please, my lord.
Yes.
Section 151 of the code empowers the court to invoke its inherent jurisdiction to prevent miscarriage of justice and abuse of process. The purpose of Section 151 is to ensure that substantive justice is not defeated by hyper-technicalities. The law courts are required to interpret to the provisions to advance the cause of justice. The interpretation of such an omnibus provision should not be crippled by a myopic provision, as the provision is intended to embrace all situations not specifically conferred on the court by the code. Then, my lord, judgments of the Supreme Court are noticed. 106 is the test. The test of granting interlocutory injunctions, I'm not troubling your lordship with. 107, the interlocutory remedy is intended to preserve the status quo, the rights of parties which may appear on a prima facie case. Then your lordship kindly comes to 111, please, my lord. There cannot be any absolute proposition that in a money claim, no order or injunction. This is, my lord, what the court had earlier held in Hurleen Jairat also. Then 112, the other decisions are noticed. 113, the very basis of an interlocutory relief is establishing a prima facie case, balance of convenience and comparative hardship. These are the three pillars on which the claim for interlocutory reliefs are to be assessed. Then kindly see 115, if the prima facie case of Tata was held to have been established. May I just show your lordship the highlighted portion once, my lord. It is also prima facie established that the claim of the appellant in the nature of an unpaid vendor to the extent of excess credit and or unauthorized rebate dehoves the price circulars, the claim is quite substantial. Then the excess of the trial court, my lord, the discretion had not been exercised. Kindly come to. All then is on, my lord, the facts of that case. 123 onwards. So in a case of fraud like this also, like our case, my lord, Order 39(1)(b) and Section 151 has been put into service and claims have been secured, my lord.
Yes.
Rahul S. Shah is noticed in paragraph 138, my lord.
Yes.
And my lord, the argument which was made, which has also been made in our case 141, if your lordship kindly sees, it has been dealt with. The order impugned considered the claim to be an unascertained sum, ignoring the fact that it is claimed towards realization of an amount that in the ultimate analysis had remained unpaid. Lordship has 141.
Yes.
The order impugned considered the claim to be an unascertained sum,
Yes.
ignoring the fact that it is claimed towards realization of amount that in the ultimate analysis had remained unpaid. The plaintiff has quantified the sum on the basis of the reports which clearly establish excess rebate or discount granted to the respondent dealings. The reports are based on primary documents and data recovered from the computers of SKS. In my case also, my lord, what is paid is shown by bank remittances. There's no cash involved, that money is not received. D1 has admitted that yes, I have received this payment, and the shipments which D1 has made and the quantity which I have received is also admitted. D6 also admits that it has only shipped these goods and nothing more.
Yes.
So, my lord, the judgment of the learned single judge was reversed, 143 and 144. So, my lord, that takes care of the decision cited by my learned friend. Factual correction, I've told your lordship, my lord, claim is for excess price of goods also. Now, my lord, what my learned friend has correctly pointed out, claim for damages cannot be secured. So, lordship will kindly, I will give a chart, my lord, reducing these claim amounts, B and C, which are on the account of damage. It's not an absolute proposition that it cannot be secured. But since they rely on these judgments, I don't want to get into protracted argument. At this stage, only at this stage, only for the excess amount. Now, my lord, the second argument which my learned friend advanced.
You stop here.
Your lordship has another. Great. The fact that the reply could pass. I'll not take more than 20 minutes next day, my lord.
Only suffering for the counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Let the matter register tomorrow. Tomorrow. 2 p.m. है कल. Tomorrow 2 p.m.
Please, man.
At 2 p.m.
When?
Tomorrow.
Wait.
हाँ.
Sir, চলছে বলবে Mr.
No, I will conclude in 20 minutes, my lord.
Because Mr. Bhattacharya won't be available and then I won't be available till 20th April. So I was
He told that he didn't let the injunction may be continued. He submitted.
No, he submitted, my lord.
He submitted, it's continued till the disposal of the suit.
No, never.
Only the injunction of Mr. Bose.
Never, my lord, never.
My lord, defendant numbers 11 and 12 would also like.
All. Give your number names here.
The interim order is expiring tomorrow. We'll renew our parade tomorrow for you. कल तो कर देंगे कल है तो मैं कल इसमें
क्या है नंबर हियरिंग
हाँ ये दिखा ये दिखा दो
Huh?
ये दिखाना
I'm for the plaintiff, my lord. I'm led by Mr. Sahab. With your permission, my lord, may I?
Your Lordship, I'm appearing for the defendant.
Yes.
My lord, this matter pertains to an insurance claim. Rather, two insurance claims between the same parties, and these two insurance claims are interlinked. So, these insurance policies are covering the risk in cold storages. In potato cold storages, there is a specially designed policy, particularly issued to the potato cold storages. These are standard policies. I mean, these policies, the clauses are standard clauses, standard form clauses. Now, my lord, in one policy, these policies are to be taken together by any party for ensuring the stock as well as ensuring the plant and machinery used in the potato cold storage. The one policy which covers the stock is deterioration of stock policy, which is abbreviated in the plaint and evidence as DOS policy, and the other is machinery breakdown policy. Now, machinery breakdown policy is for covering the refrigeration plant and machinery. In this matter, my lord, what happened after the potato loading season starts
You
from
already argued.
Yes, my lord.
That I have taken note of it.
My lord, the only dispute. This is an uncontested suit. The only dispute relating to the MBT policy, the DOS policy, that is stock policy, is regarding the interpretation of the insurance contract. Now, my lord, may I place the interpretation, the clause which is required to be interpreted? Now, in this matter, my lord, one aspect is very important, that quantum of loss, that is an admitted position. That has been assessed by the surveyor appointed by the insurance company, and he has.
And whether it is covered under.
It is covered under the policy or not. That is
the excess heat.
Excess heat, my lord.
Excess heat.
My lord, excess heat. I'm indicating from the policy itself, my lord. Jumbled up the volumes. My lord, kindly sees the deterioration of stock policy, my lord, in the judge's brief of documents. At page 77. Well, the policy, this is the stock policy. The policy begins from page 73. Policy begins from page 73. That is the schedule of the policy, mentioning the premium and the stock, that volume of stock that is insured. But the standard clauses start from
page 73.
73 of the judge's brief, my lord. It will be in volume 1.
Yes.
Now, relevant clause starts from, my lord, page 77. That is the after the preamble of the policy, that is the overall coverage declaration in the standard clause policy. Now, my lord, may I read out? Now, this, my lord, second paragraph at page 77.
Yes.
Now, this policy of insurance witnesses that in consideration of the insured having paid to the company the premium mentioned in the said schedule. Schedule is where the premium and the volume is mentioned. The company hereby agree with the insured, subject always to the terms, provisions, warranties, and conditions contained herein or endorsed hereon. That, well, here, from here, the relevant portion starts. If at any time during the period of insurance, now, my lord, stated in the schedule or during any subsequent period for which the insurance pays, the company may accept the premium for renewal of this policy. Now, my lord, now the relevant portion starts. There shall occur an accident,
Correct,
as hereinafter defined, to the refrigeration machinery described in the schedule 1. Now, resulting in a rise in temperature in the refrigeration chambers, thereby directly causing damage to the goods described in schedule 2 by deterioration and putrefaction or contamination following such accident. So, my humble submission in this matter, my lord, under this policy, 2 different perils are covered. One peril is stoppage of refrigeration due to some accident, and the temperature goes up, and due to rottage comes in, which is this putrefaction and deterioration is, in common parlance, this is rotting. That starts. The other peril is that due to some damage in the refrigeration machinery, a leakage occurs and the coolant, the refrigerant.
That is not your case.
Well, that is my case. My case is due to accident and breakage in the valve, the refrigerant ammonia gas escaped in the chamber and that contaminated the entire stock in chamber number 3. That is my case. So my case is I fall under peril now, the second peril.
Where is that?
My lord, I am showing, my lord. I'll show from the survey report as well as
From the condition.
My lord.
If page 77.
My lord.
If any time during the period of insurance stated the schedule or during the subsequent period of which the insured pays, the company may accept the premium. So shall occur an accident and hereinafter defined the refrigeration machinery described in the schedule 1 resulting in rise of temperature.
Yes, my lord.
Correct. In the refrigeration chamber, thereby directly causing damage to the described schedule 2 detergent purification such accident, then the company will subject to the terms, exception, warranties, conditions, endorsement, otherwise express therein, but not exceeding in all the sum insured stated in schedule 2. The total liability of the company under this policy limited to the sum insured. Yes. So this is one condition.
Well, my case is that my damage to my stock in chamber number 3, which is about around 8 crores, value is about 8 crores, was due to escape of ammonia gas into the chamber due to breakage of valve, and that contaminated the entire stock, rendering that unfit for human consumption. We have a lab report also taken by the surveyor. Now, my case is, my lord, that so far the loss due to contamination is concerned, it's a separate peril. It has no nexus or no prerequisite to be covered that temperature should increase. Increase in temperature causing rottage is one kind of peril, and contamination is a different kind of peril. Now, my lord, that will be more clear from the definition of accident. This clause states that accident hereinafter defined, and the policy defines the accident. My lord, kindly comes to page 78, where the expression definition for the purpose of this policy is defined.
Yes.
My lord, definitions. The term accident shall mean and be limited to A, any sudden or unforeseen loss or damage to the refrigeration machinery described in Schedule 1 of this policy due to any accidental cause covered by the machinery insurance policy specified in Schedule 1 and not hereinafter excluded. And number B, escape of refrigerant in the refrigerated chamber as a direct result of damage to the machinery and plant described in Schedule 1, for which damage a claim is admissible under machinery insurance policy. Now, my lord, my submission is the definition of accident for the purpose of this policy also is twofold. There are two types of incidents which are brought under the purview of the expression accident. One is breakdown in the machinery and consequences thereof, which certainly amounts to leads to rather rise in temperature for certain period and then damage to the stock. The other has no nexus with is contamination, which is due to escape of refrigerant. So escape of refrigerant from the system into the chamber itself is an accident, which doesn't require any rise in temperature for causing damage to the stock.
So what the report says?
Well, the
How
report
the temperature rise?
Well, in my case, temperature didn't raise. Didn't raise.
So,
And my lord.
So what the insurance company says?
My lord, insurance, my lord, I'm showing the repudiation letter, my lord. It is in page 197 of the judge's brief. It has in volume 2, my lord. The insurance company has relied on two exclusion clauses, which exclusion clauses say that since your temperature has not risen beyond 24 hours and up to a temperature of 40 degrees centigrade, so 40 degree Fahrenheit, so claim is not payable. My whole contention has been in the plaint, and before I initiated the suit, that my loss is by contamination. For that, rise of temperature is not required, and a common man's interpretation is the same as I am interpreting, that contamination is a species of peril.
How the contamination occurred?
My lord, it occurred due to, in the refrigeration chamber, there are valves, there are pipelines
Correct.
through which the liquid ammonia circulates.
Correct.
Now, one valve broke due to sudden rise in pressure in the vapor, and the valve broke and ammonia escaped, and that spread.
Due to the spread of the ammonia, your
Yes,
materials have
my
been
lord.
lost.
Yes, my lord.
Correct. Sir, that's why that is called the accident.
That is the accident.
As per your submission, that is the accident.
My lord.
So what the insurance company says?
My lord, insurance company's reputation is 197. In sum and substance, this is a repudiation letter. In sum and substance, my lord, may I read out, my lord? My lord, insurance company initially communicated the repudiation by email, then sent a letter. Contents of both are same.
Correct.
So, my lord, I am reading out from the letter, which is
197.
199, my lord. That is a letter. Its contents are same. My lord, by one letter, they repudiated claims under two policies.
Correct.
The DOS policy, the stock policy, is the subsequent page 200.
Yes.
DOS operative clause, at the time of happening of an accident, there shall be in force of insurance covering the interest of the insured in costs of repair or replacing of the insured machinery necessitated by such accident, and that the payment shall have to be made or liabilities admitted therefore under the insurance. But if no payment shall have been made or liability admitted under such insurance solely or as a result of operation of any excess, they are under the liability of the company under this policy shall not be affected. Now, DOS exclusions. Now, here they say that your claim under machinery policy is not payable, so this policy is not payable. That is one part. I'm coming to that, my lord, later. Because I will show that insurance company admitted liability under the machinery policy. Then they became wiser that ground of repudiation in the stock policy will not sustain in court of law. So, catch the handle of machinery policy and repudiate that so that they don't come under DOS policy. So I will explain that, my lord, with the sequence of events. I'll indicate the sequence of events. But my lord, can you see the exclusions they invoked for stock policy? Exclusion number 3. Any damage to the stock due to rise or fall in temperature caused by stoppage or stoppage of any section or sections of the refrigeration plant for less than 24 hours following an accident to the refrigeration plant and machinery specified in schedule and covered by concurrent machinery insurance policy. So the sum and substance is 24 hours. It was not stopped machinery. My lord, that this clause is operative in case of cold storages. My lord, if we look into the business efficacy angle of any commercial contract, this clause is applicable when after an accident or without any accident, a machinery is overhauled. So it will take some time. The repair takes some time. If that repair, during that repair, this policy stops operating. My lord, number 2. And if that repair, if that is for less than 24 hours, then this policy doesn't cover. Number 2, any damage to stocks caused by a risk or a rise or fall in temperature due to stoppage of any section or sections of the refrigeration plant for repairs, maintenance, overhauling, or for replacement or parts due to wear and tear of the plant and equipment or failure of any part requiring periodical renewal. Now, my lord, here, first of all, insurance company has to prove that this damage was due to failure of a plant, a part of the machinery which required regular repairs, repairs against wear and tear. So I'm coming that in that way, this policy connects to the MBD policy. But in sum and substance, the ground of repudiation, the second ground I'm showing that failure of a machinery, part of the machinery covered under the MBD policy, machinery breakdown policy, which requires regular upkeep and repair, and failure of which due to wear and tear excludes claim under DOS policy, which is not this case. Second is, my lord, the rise of temperature, no rise of temperature at up to 40 Fahrenheit and for less than 24 hours. So the policy is excluded. In my humble submission, my lord, rise and fall of temperature has nothing to do with contamination. If that interpretation is adopted by the insurance company, then my lord, that will fail the business efficacy test, and that will also be hit by the contra preferentem rule. Because at best, so far, the understanding of common man about the term contamination, insured has gone to insurance company, asking the insurance company, give me two covers. One cover is, if the temperature rises, if my stock rots, please cover it. And if there is a contamination, please cover me against contamination. So the insured approaches an insurance company to obtain a policy for covering two separate perils. Now, my lord, and I'll show the discharge voucher in the MBT policy. Now, my lord, I'll show contamination. I'll show the common man's dictionary, Oxford Dictionary meaning of contamination. The meaning of contamination, and I have checked the scientific dictionaries also, but I am not relying on that. Contamination is some pollutant is introduced to a particular item, and that becomes contaminated. I drop some mud into water, the water becomes contaminated. So contamination necessarily requires intervention of an external item, an external agency, some external pollutant or some external agent. A foreign agent has to be induced, then only contamination can happen. For water contamination, for chemical contamination, whatever contamination, an external agent has to be induced into the item which is contaminated. So far, my lord, rottage, putrefaction or deterioration, which is rottage basically, that happens due to inherent nature of a product. It doesn't need any external agent to intervene to cause its damage. So, my lord, so in the nature of the peril itself, these two perils, there's a distinction. Suppose I keep a piece of potato in the refrigerator, it will survive for 1 month. I keep it outside the refrigerator, it will rot within 2 days or within a day. So, my lord, this will happen, this damage will happen because of the inherent character of the item which is insured. It doesn't require any external agency. Rotting of food item is an inherent nature, inherent vice of the item. Whereas contamination of any product, be it a liquid, be it a food, it needs interference or inducement of any external, any foreign agent to get it damaged. So this is my humble submission, my lord. These two are different perils altogether. Insurance company has juxtaposed one peril with other simply for repudiating my claim, because it's a huge claim. And my lord, I'll show another aspect, why I in the worst case scenario, if two meanings are possible, then a meaning which induces the insured or which leads the insured to rely on the policy wordings and obtain the policy has to be adopted. That is a contra preferentem rule, because the terms and conditions of the policy have not been chosen by me. I have no right to alter a single punctuation mark in the policy. These are standard form policies. My lord, may I take your leave? My lord, I'm led by Mr. Saha.
With your lordship's leave, my lord.
Yes.
But the only question that falls for your lordship's consideration is, my lord, the interpretation of the policy. The question is, how is the policy to be read? Now, my lord, for that, my lord, so far as interpretation of insurance policies are concerned, my lord, those are governed by, my lord, special terms. Now, my lord, at the very, my lord, fundamental basis of all insurance policies is, my lord, the contract of ivorime fide. It's a contract of utmost good faith. Now, my lord, therefore, the insured has an obligation to make a complete and full declaration of, my lord, all that can ultimately come to visit him or plague him. And my lord, the insurer is also under an obligation to, my lord, honor the policy if the policy has been taken out for a purpose. Now, my lord, so far as the policy is concerned, your lordship may have been told that, my lord, I have no choice over the insurance company. I have to choose from among the insurance companies that are specified by the government. I also have no choice, my lord, over the premium or, my lord, over the, my lord, rental that I will charge from, my lord, the potato growers. So, my lord, it is really all structured by the state. I have no choice over the, my lord, insurer. I have no choice over the terms of the insurance policy. These are all standard terms contract. So, my lord, when your lordship is interpreting a standard term contract, my lord, as my learned friend, I heard him say, your lordship is applying the contra preferentum rule. That, my lord, if there are two interpretations possible, one in favor of the maker of the instrument, once against him, my lord, the interpretation against the maker of the instrument will be adopted. But that is not, my lord, fundamental. What is important is, my lord, your lordships are required now when reading any contract, any deed or document, your lordships are required to give effect to all its clauses. The first attempt or first object is to harmonize, my lord, all the clauses of the contract, so that, my lord, upon harmonizing the clauses of the contract, it can be, my lord, ultimately gathered that, my lord, all, my lord, are, my lord, capable of being reconciled with each other. So, my lord, the first rule of construction of deeds and documents, not, my lord, notwithstanding the special character of insurance contracts, is the rule of harmonizing. So, my lord, the document will have to be read harmoniously in an attempt to give effect to all its clauses. In doing so, my lord, care will have to be taken to ensure that no part or portion of, my lord, the clause is rendered odious or a surplusage. Now, if I read a contract in a particular fashion, which will ultimately do violence to another part of the contract, which will then render it completely meaningless, then, my lord, that is not to be adopted. And the third, of course, is, my lord, if two interpretations are possible, then, my lord, the contra preferentum rule. And, my lord, finally, the, my lord, most, my lord, important rule of construction, my lord, in insurance policies is, my lord, ultimately to, my lord, give effect to the policy to the extent possible to ultimately cover the risk for which the policy has been taken out. Now, my lord, straight away coming to, my lord, the internal page, my lord, this is page. Page
77.
Well, at page 77, if your lordship will come, just one. Volume 1, page 77. Well, kindly just read this one clause with me. Well, it starts, my lord, after the first, my lord, paragraph. It says, now this policy of insurance witnesses. Well, lord, may I read this a little slowly? Now this policy of insurance witnesses that in consideration of the insured having paid to the company the premium mentioned in the said schedule, the company hereby agrees with the insured, subject always to the terms, provisions, warranties, and conditions contained herein or endorsed hereon, that if at any time during the period of insurance stated in the schedule, or during any subsequent period for which the insurer pays and the company may accept the premium for renewal of this policy, there shall occur an accident. Now, whether accident is defined, I shall take your lordship to it.
Correct.
There shall occur an accident as hereinafter defined. To accident to what? To the refrigeration machinery described in Schedule 1, resulting in rise in temperature in the refrigeration chambers, thereby directly causing damage to the goods described in Schedule 2. Now, my lord, kindly pause here for a moment. So, my lord, today, if there is, my lord, accident to the refrigeration machinery, now, my lord, there is a, my lord, separate plant and, my lord, plant and machinery insurance also. If there's an accident to, my lord, the refrigeration machinery, my lord, what will happen? The refrigeration will stop. What is the consequence? Temperature will rise. What is the cause? Result in? Well, purification of the goods. Now, resulting in rise in temperature in the refrigeration chambers, thereby directly causing damage to the goods described in Schedule 2 by deterioration, putrefaction, or contamination. Now, my lord, may I just pause here for a moment? Now, my lord, today, my lord, because of rise in temperature, there may be, my lord, deterioration. The quality may not be, my lord, up to the mark. There may be putrefaction. It may be completely, my lord, wasted. But, my lord, kindly see contamination. Contamination is something, my lord, that requires an external agency, my lord, to be the contaminant. It is not, my lord, something that is associated with rise in temperature. Now, my lord, what the policy seeks to cover is, my lord, my lord, damage to plant and machinery. Why, my lord? Because plant and machinery, if damaged, will consequently damage the stock. but two separate policies, two separate premiums, two separate periods. So, my lord, if plant and machinery is damaged, automatically
Period is also separate.
period is same.
Correct.
Period is same. My lord. Two separate periods and says they run parallel. So, my lord, number one is that, my lord, today there is a plant and machinery policy, which I shall show you, lordship, which says that if the plant and machinery breaks down, then, my lord, you will be compensated. And, my lord, there is also a requirement of ensuring that the plant and machinery is maintained. Now, my lord, I have been insuring my goods with the same insurance company for the past, my lord, 14 years. And, my lord, for the past 14 years, there has been no claim on account of damage to plant and machinery. That is a pleaded case. And, my lord, every time before, my lord, the policy is renewed, there is an inspection caused to the plant and machinery by their own, my lord, surveyor and assessor, or my lord, by an inspection agency who, my lord, comes and certifies and says that the plant and machinery is not subject to natural wear and tear, or, my lord, is maintained and kept up to the mark. Because, my lord, otherwise, for example, my lord, if I go, my lord, to obtain a medical policy, a mediclaim policy, and, my lord, I disclose the fact that I am suffering from a very serious heart ailment, the policy will not be given to me. Similarly, my lord, when today it's a, my lord, machinery and plant breakdown policy, and the disclosure is made to the effect that, my lord, the plant and machine is a decrepit state, my lord, then naturally the policy will not be renewed. Now, my lord, the question is, my lord, if today there is, my lord, damage to the plant and machinery, it may affect the refrigeration system, it may lead to rising of temperatures, may lead to deterioration and putrefaction. But contamination, my lord, when you also protect me against contamination, then, my lord, that has to be read, my lord, apart. Because otherwise, my lord,
Whether there is any report with regard to the what is it is contaminated.
No,
The
my lord, what is
materials
said,
which you have kept in the cold storage, whether it is contaminated or it has damaged.
no, my lord, contaminated. There was ammonia leakage.
No, what is the report? You might have been
The
sent
report is, my lord, ammonia leakage.
ammonia. No, what ammonia leakage from the machinery?
That's
from
right.
the pipe. From the pipe.
Yes.
For that, the materials, the articles which you have kept, the potatoes and all
Yes.
these things, whether that was damaged, it is a contaminated.
Yes. Report is it was damaged due to, my lord, the contamination in connection upon coming in contact with the ammonia. That is the clear report.
Correct.
Now, my lord, my learned friends have proceeded to repudiate the polity, saying that yes, it may have been damaged due to, my lord, contamination by ammonia, but not because of rise in temperature.
Correct.
Well, that is the long and short of the entire case. Well, it is a question of repudiation of policy. Now, my lord, today, if you accept that there's a breakdown in machinery, which has not, however, resulted in rise in temperature, you say that you're obliged to compensate me for the breakdown in machinery. Of course, my lord, the compensation that has been awarded is, my lord, laughable. But, my lord, you accept that there's been breakdown of machinery. But breakdown of machinery is something that you compensate me for. But this has not led to increase in temperature, but contamination. The question is, how is the contract to be reconciled? How do you reconcile the term contamination with the term increase in temperature? You cannot. Because, my lord, these are completely two independent facets. And, my lord, if the word contamination is, my lord, included in the policy, in that case, my lord, the understanding of, my lord, both the insurer and the insured is that, my lord, contamination is a risk covered. If contamination is a risk covered, then you cannot today say, I shall not pay you for the contamination because it is not the result of increase in temperature. Well, that is really the whole case. Now, well, so far as this is concerned, if your lordship will kindly have a look at, well, the definition of accident in this policy, at page 7,
78. Yes,
78. Well, please see the definition. The term accident shall mean and be limited to, well, of course, A is any sudden or unforeseen loss or damage to the refrigeration machinery described in Schedule 1 of this policy due to any accidental cause covered by machinery insurance policy. Well, accident to machinery. Well, there's a blast, there's a short circuit, well, there's an electrical fire, whatever. Exclusions. Failure of any part or parts requiring periodical renewal, such as failure of belts, gaskets, packing material, kind and insulation, operation of fuses and safety devices. So, Mala, these are exclusions. So, but if it is a result of accident, the machinery is damaged, then you will be compensated unless it is, Mala, to a part, Mala, which requires regular replacement. Mala, that is not the case here. And my lord, there was an inspection done by their own agency which certified that the machinery was in order.
Machinery was in order.
Yes. My lord, page 52 to 89 is the report. My lord, I shall take your lordship. Just showing your lordship the policy details first. Then my lord, B is my lord, escape of refrigerant in the refrigerated chamber as a direct result of the damage to machinery and plant described in Schedule 1 for which damage a claim is admissible under the Machinery Insurance Possible. So, my lord, accident, my lord, is limited to this. My lord, accident is limited to, my lord, escape of refrigerant.
Yes.
My lord, in the second part. Now, my lord, please see the exceptions so far as this policy is concerned. And it is under this exception that, my lord, my claim has been repudiated. The company shall not be liable for, please see Roman 2, any damage to the stocks due to rise or fall in temperature caused by stoppage of any section or sections of the refrigeration plant for less than 24 hours, following an accident in the refrigeration plant and machinery specified in Schedule 1. Well, what they say is if there's a breakdown and shut off of the refrigeration system for 24 hours, I'll not compensate you. It has to be more than 24 hours. That's the first valid concern. Then, my lord, Roman 5 is what they've relied on. Any damage to stocks arising out of overloading of the refrigeration plant and equipment beyond its maximum rated capacity. No charge to this effect. Now, my lord, what they have said, my lord, if your lordship will now have a look at the, my lord, letter repudiation letter to that.
Mail and letter both.
My lord, please see, my lord, page 197 and 199. My lord, please see, my lord, the repudiation, my lord, letter. My lord, may I just read it once again? Your lordship has seen it once. No. DOS to the
next page.
No?
Letter this is DOS.
Now, my lord, this is the MBD and DOS. My lord, kindly see. Kindly refer to the claim lodged by you under policy such and such, machinery breakdown policy. With intimation, we had deputed the surveyor on close scrutiny of the paper submitted by you and the report submitted by the surveyor in support of your claim. Vis-a-vis terms and conditions of the policy issued, we regret to inform you both the claims have been repudiated under the following exclusions and clauses. Machinery breakdown, my lord, they say, gradually developing flaws, defects, cracks or partial fractures in any part, not necessitating immediate stoppage, although at some future time repair or renewal of the parts affected may be necessary. So, my lord, it is basically breakdown, my lord, wear and tear of machinery. Gradually developing flaws. Now, my lord, so far as gradually developing flaws is concerned, my lord, it is something, my lord, for example, my lord, if today a cornice of yes. Well, they say that it's about to fall, overhanging. Well, it's a gradually developing flaw. Then, deterioration of a wearing away or wearing out of any part of the machine caused by naturally resulting from normal use or exposure. Well, which translates into the fact that, my lord, if anything, my lord, is required to be replaced, then you will replace it.
Correct.
Now, my lord, kindly see, the reliance on this clause is, my lord, only, my lord, with regard to reference to the clause without stating as to what, my lord, was the finding on which, my lord, these clauses were attracted.
So they have taken the exclusion clause 4 and 5.
That's right. That is for MBD, machinery breakdown. Then, my lord, next page. My lord, this is the, my lord, stock. DOS operative clause.
Correct.
At the time of happening of an accident, there shall be in force an insurance covering the interest of the insured in the costs of repair to or replacing the insured machinery necessitated by such accident, and that the payment shall have been made or liabilities admitted therebefore under such insurance, but if no payment shall have been made, etc. My lord, this is not, my lord, important.
So this machinery belongs to whom?
Machinery belongs to me. Yes.
Okay.
Then, my lord, exclusion 3. DOS exclusions. Any damage to stocks due to rise or fall in temperature caused by stoppage of any section or sections of the refrigeration plant for less than 24 hours following an accident to the refrigeration plant and machinery specified in schedule and covered concurrently by machine insurance policy, this is excluded. So, my lord, it has to be for more than 24 hours. The breakdown in the refrigeration system. Then, 4. Any damage to stocks caused by a rise or fall in temperature due to stoppage of any section or sections of the refrigeration plant for repairs, maintenance, overhauling, or for replacement of parts due to wear and tear of the plant and equipment, or failure of any parts requiring periodical renewal and operational fuses and safety devices. However, this exception will not apply for repairs or replacements. So, my lord, if in the course of repairing or replacing any part or section of the refrigeration plant, or for its overhauling and maintenance, well, if there's any damage to the stock, that is not covered. Now, well, here, well, kindly also see exclusion number Roman 6. Any damage if the temperature in the refrigeration chamber does not exceed 40 degrees Celsius. Now, well, again, no attempt to ultimately say as to how these clauses become applicable to the risk in question. Well, it is by mechanically, my lord, referring to certain clauses and, my lord, trying to ultimately seek to place reliance on these clauses to avoid the claim. Now, my lord, the report.
They have not filed the written statement.
No, they have not filed it. Uncontested. It's, my lord, undefended.
And what is why the 24 hours cut-off time is given?
I'll tell you, Lordship, my lord, today, it is possible that, my lord, ultimately, my lord, we are storing, my lord, large quantities of potato. We have a refrigerator system. It's a mechanical system. It may, my lord, suffer from a failure. But, my lord, immediately, my lord, attempts are always made to rectify the system. Now, my lord, today, if it is for less than 24 hours, then, my lord, the stocks will not, my lord, suffer, because, my lord, the chambers will continue to remain cool. It might not, my lord, be maintained at the same temperature. But, my lord, up to 24 hours, my lord, the presumption is that, my lord, there will be no deterioration, no putrefaction, because the chambers will still be cool, and, my lord, the time lag will not be sufficient to affect the quality of the goods. That is, my lord, the 24-hour timeline. Secondly, my lord, so far as breakdown of machinery is concerned, I said that if you have not maintained your machinery and your machinery fails, and as a result the stock suffers, it is for your fault. You can't take advantage of your own wrong. Naturally. But, my lord, also, for this, my lord, there's a parallel policy for machinery breakdown. And, my lord, what is the object of these two separate policies? One is, my lord, you are saying, taking from me a separate insurance, my lord, for breakdown of machinery. And you're obligating me to ensure that the machinery is maintained in a proper, my lord, condition, because it is at that point of time that you are deputing your representative to check the machinery, to check the plant, to ascertain that they are, my lord, in good order, and only then are you issuing the policy. My lord, this is all on record. That's number one. Number two, my lord, kindly see the nexus between the machinery policy and the DOS policy. Now, the machinery policy says that if there's a breakdown of machinery, I'll compensate you. And the DOS policy says, stock policy, that if there's a breakdown of machinery and the goods suffer as a consequence, I will compensate you. But the exclusion is, and well, this is a practical exclusion, that if today the machinery breaks down only for 24 hours, then you can't claim rotting of stocks because
it will not damage.
That's right. So you can't say that you have put in stocks there which are already in a pre-rotten condition and claim money for that. And says that if today you have failed to maintain in machinery, for which, my lord, normal wear and tear is, my lord, envisaged, because, my lord, that requires replacement. My lord, I will require to replace, my lord, my fuel in the car. I will require to replace, my lord, my wipers from time to time. I will require to replace the tires from time to time. I will require to change, my lord, the mobile oil from time to time, to fill coolant from time to time. My lord, these are things I must do. So if you find that I have not done any of these activities so far as meeting, then you will
negligence on the part.
My lord, there is no such finding. No such finding, because, my lord, they ultimately deputed a surveyor. And, my lord, they have relied on the surveyor's report for the purpose of repudiating my claim. Now, your lordship will look into the surveyor's report, both with regard to, my lord, the claim for machinery breakdown and DOSs, and find out as to, my lord, whether they've established any connect.
So you have made a claim of both?
Yes. Now, my lord, so far as interestingly, my lord, when, my lord, I make a claim for, my lord, breakdown of machinery, they, my lord, assess my claim at a pittance, because, my lord, ultimately, what they really find is, my lord, there was only a valve which had gone wrong. So, my lord, naturally, the entire machinery did not have to be, my lord, replaced or, my lord, claim. It was only a valve, my lord, which had gone wrong. They had not come to the conclusion that, my lord, I had tampered with the valve. They have not come to the conclusion.
It is
that
your negligence.
It is my negligence, or the fact that this was required to be replaced at certain intervals, which
Not
was
properly
not done.
maintained.
No such finding. So, my lord, they first, my lord, ultimately allow my policy, give me a discharge voucher, ask me to sign the discharge voucher. I sign the discharge voucher, send it to them, then they don't accept it. Because what they realize If they accept,
Accept, then they have to give.
if they accept that there's a breakdown in machinery, then my lord, there will be automatically a claim here. So my lord, they gave me a discharge voucher. They asked me to fill it up, sign it, and send it back to them. I send it back to them, but then my lord, they keep quiet, and then they proceed to subsequently repudiate the machinery breakdown policy and to repudiate the stock policy. So my lord, the only question that my lord ultimately my lord requires your lordship's consideration is, my lord, whether my lord A, the terms of the policy, my lord, say that no, I can only receive compensation if there is damage due to my lord rising temperature for a period in excess of 24 hours, or my lord, whether I can also claim loss on account of contamination as a result of breakdown of machinery.
Connected with.
That's right. That is the only question. And my lord, that is why the matter is very short. Now, my lord, all that I need to show your lordship now are, my lord, A, my lord, what they had initially said with regard to machinery breakdown, discharge voucher, not accepted, the reasons for rejecting. B, what they had said with regard to, my lord, the stock policy, and my lord, whether they have related it to any of them. And my lord, third is, my lord, today you cannot read an insurance contract in the manner in which the insurance company has sought to do. This is against, my lord, very ethics of, my lord, entering into contract. Yes. Well, that is all. So I think another half an hour, and my lord, we can finish this. Thank you.
So suffering for the plaintiff. So suffering for the defendant. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Any time he's there. Tomorrow at 3:45.
Well, if your lordship permits me to join virtually, my lord.
No problem.
I will not be in Calcutta, but I would like to finish this.
No problem.
Kalki court. 3:45 tomorrow.
Tomorrow at 3:45.
Don't worry.
Much obliged, Your Lordship.
George, তাড়াতাড়ি ইচ্ছে করে দাও।